Weekly list item number 5.
Item 5 after 6. I'm calling for the short.
Item number 6.
Yes, madam.
Sarojini Singh, DSP Jagatsinghpur.
What development has been made? You appeared before this court from some 31/10/2023. On that day, we grant you time. It is almost a month has passed in the meantime. So, whether the victim has been rescued and the accused has been arrested?
Accused victim rescue
No. It's all right. But what steps you have taken for last 1 month, that we want to know. And where is that status report?
What was last day before yesterday? Filed it before my lord. My lord was putting some query regarding the status report. That's why on that day she was not there.
No visible development was there in the investigation.
No, why have you repeated all those things? We want that what development has been made after 31/10/2023. These are all old things that 31/10/2023 ପରେ ଆପଣ କଣ କଲେ ସେ ବିଷୟରେ ଆପଣଙ୍କୁ ଷ୍ଟାଟସ ରିପୋର୍ଟରେ ଉଲ୍ଲେଖ କରିବାର ଥିଲା। ଆଉ ପୁରୁଣା ଆଗରୁ କଣ କରିଯାଇଛନ୍ତି ତାକୁ ପୁରା ଆପଣ ଦେଇଥିଲେ ଆଗରୁ ତାକୁ ଆମେ ଦେଖିଥିଲୁ ତ ତାକୁ ସେଗୁଡା କଣ ପାଇଁ ରିପିଟ କରୁଛନ୍ତି ଆପଣ? ଯେ କଣ କରିଛନ୍ତି କହୁନାହାନ୍ତି କଣ?
ତାଙ୍କ ତ ମୋବାଇଲ 2 ଜଣଙ୍କ ଯାକ ସୁଇଚ ଅଫ୍ ଅଛି ଆଉ ତାଙ୍କୁ କୌଣସି ମିଳୁନଥିଲା। ଆମେ ତାଙ୍କ ଖୁଡି ଜଣେ ଅଛି, ମୁଁ 2-3 ଥର ଇଏରେ ଯାଇକି ରିକ୍ୱେଷ୍ଟ କଲା ପରେ ତା ଖୁଡି କହିଲା ଯେ ସେମାନେ ଗପୁଛନ୍ତି, ତା ସାନ ଭଉଣୀ ଆଉ ତା ବାପା ବେଳେ ବେଳେ କଥା ହଉଛନ୍ତି, ଆପଣ ତାଙ୍କୁ କହୁନାହାନ୍ତି ପଚାରୁନ ତା ମୋବାଇଲ। ତେଣୁ ସେ
କାହା ସାଙ୍ଗରେ ଗପୁଛନ୍ତି?
ସେ ଆକ୍ୟୁଜ ସହିତ
ହଁ
ସେ ତାପରେ ଆମ ହୋମଗାର୍ଡ ଡେପ୍ଲୟ କଲୁ। 3-4 ଦିନ ପ୍ଲେନ ଟ୍ରେସ୍ ହେଲା ପରେ ତାର ସାନ ଭଉଣୀର ନମ୍ବର ଗୋଟେ ପାଇଲୁ। ସେଇଟା ସାବ ସିଡିଆର ମାଗିଥିଲୁ ଏବଂ ଗତକାଲି ସାବ ପାଇଲୁ। ସେଥିରେ 2ଟା ନମ୍ବରକୁ କଣ୍ଟିନ୍ୟୁଅସଲି ଗପିଛି ରାତିରେ। ସେଥିରୁ ସବୁ ତାର ସିଡିଆର ପୁଣି ସେ ଲୋକେସନ ଆମେ ମାଗିଛୁ, ଗତକାଲି ପୁଣି ମାଗିଛୁ ସିଡିଆର। ସେ ପର୍ସନ କିଏ ତା ମାଧ୍ୟମରେ ଆମେ ସୋର୍ସ ପାଉଛୁ ଯେ ତା ମାଧ୍ୟମରେ ସେ କଥାବାର୍ତ୍ତା ହଉଛନ୍ତି। ସେ ଡାଇରେକ୍ଟ କାହାକୁ କଥାବାର୍ତ୍ତା କରୁନାହିଁ, ତା ମୋବାଇଲ ନାହିଁ। ତେଣୁ ସାବ
ଅନ୍ୟ ଫୋନ ରୁ କଥାବାର୍ତ୍ତା କରୁଛି ଏହା ଜାଣୁଛନ୍ତି, କିନ୍ତୁ ପ୍ରାୟ ରାତିରେ କଥାବାର୍ତ୍ତା ହଉଛି। ହଁ, ଯେ ସେଇ ଯୋଉ ମୋବାଇଲ କୁ ତାକୁ ଟ୍ରାକିଂ କରୁନାହାନ୍ତି କୋଉଠୁ ଯଦି ବା କଣ କନଭରସେସନ ହଉଛି ତାଙ୍କ ଭିତରେ, that you can also ask to record and hear that what is the nature of conversation. If you make a request in view of that you can know whether he is that person with whom this girl was talking, is whether this accused or somebody else. Might be somebody else. କାହା ସାଙ୍ଗରେ କଥା ଆମର we are concerned with the boy who has kidnapped the minor girl. ତେଣୁ ଆପଣ ଯଦି ଗୋଟେ ଫୋନ ନମ୍ବର ଜାଣି ସାରିଲେଣି ट्रैकिंग तो ହେଇଯିବ କୋଉଠୁ ଆସୁଛି ସେ ଫୋନ ରୁ
ସାର୍
କାହାର ବି ସେ ଫୋନ ମଧ୍ୟ ଜଣା ପଡିଯିବ but the thing is that whether this is ଯୋଉ conversation nature of conversation ରୁ ସେଟା ତା ଭାଇ ସାଙ୍ଗରେ କି ଆଉ କା ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା
ସାର୍
ତେଣୁ ଏ ବିଷୟରେ ଜାଣିବା ଦରକାର।
ସାବ ସେଟା ସାବ ଗତକାଲି ପାଇଲା ପରେ ପୁଣି ସେଇ ଯୋଉ ନମ୍ବର ସେ ଗପୁଛି କଣ୍ଟିନ୍ୟୁଅସଲି ରାତିରେ ଆମେ ରେଡ୍ କଲା ପରେ ସାବ ବେଶୀ କଥା ହେଇଛି ସେ ନମ୍ବର ସହିତ।
ହୁଁ
ତେଣୁ ଆମେ ଅନୁମାନ କରୁଛୁ ସେଇ ତା ଭାଇ ସହିତ ବୋଧେ ପୁଲିସ ଯୋଉ ଯାଉଛି ତାକୁ ସୋର୍ସ ଇନଫର୍ମେସନ ଦଉଛି। ସାବ ୟା ପରେ ତାପରେ ବି ଆଉ ଗୋଟେ ସାବଙ୍କ ଆଦେଶ ଅନୁସାରେ ଯୋଉ ଯିଏ ପିଲା ତାକୁ ଛାଡିବା ପାଇଁ ଯାଇଥିଲା ସେ ପୁଅକୁ ଆଉ ଝିଅକୁ ସେ ପିଲାଟାକୁ କାଲି ଆମେ ଉଠେଇଛୁ ରାତି 2ଟାରେ। ସେ ତା ବାଇକ ରେ ଛାଡିବା ପାଇଁ ଯାଇଛି ସାବ ତାକୁ ଆଣି ଥାନାରେ ଅଟକୁଛି ତାକୁ ପଚରାପୁଚି କରିଛୁ। ସେ କହୁଛି ମୁଁ ତାକୁ କନ୍ଦରପୁରରେ ବାଇକ ରେ ନେଇକି ଛାଡିଲି ତାପରେ କୁଆଡେ ଯାଇଛନ୍ତି ମୁଁ ଜାଣିନାହିଁ। ଆଉ କାହା ସହିତ ସାବ ତାର ଆଉ ଲିଙ୍କ ନାହିଁ। ସେ ପିଲାର ମୋବାଇଲ ସୁଇଚ ଅଫ୍ କରିକି ରଖିଛି।
ଆପଣଙ୍କ ହାତରେ ଗୋଟେ କ୍ଲୁ ମିଳିଲାଣି
ହଁ ସାବ
ଯୋଉ ଭଉଣୀ କାହା ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା ହଉଛି
ସାବ
ତ ଭଉଣୀର ହୁଏତ ସେ ଲଭର ହେଇଥାଇପାରେ କିଏ ଜାଣେ।
ହଁ
ତେଣୁ
ସାବ ସେଇଟା
ଜିନିଷଟା ହଉଛି we are concerned with the person if he is the accused in this case or not।
ସାବ
ତେଣୁ ସେଇ କଥାବାର୍ତ୍ତାରୁ ହିଁ ଆପଣ ଇଏ କଲେ ଆପଣ ଜାଣିପାରିବେ।
ସାବ
So why are you not making a prayer that this is the case and so
କରିଛୁ ସାବ ମୁଁ କେସ୍ ନେଲା ପରେ ମୁଁ ତ ସାବ ICW କ୍ରାଇମ ଡିଏସପି
ଏକ ତ ଆପଣ ଜାଣିପାରିବେ କୋଉ ଏରିଆରୁ ଫୋନ ଆସୁଛି
ସାର୍
କୋଉ ସେଇଟା ଗୋଟେ ଜାଣିପାରିବେ। ନେଚର ଅଫ ଟକିଂ ରୁ ଜଣା ପଡିବ। ଭଏସ ଯଦି ଆପଣ ଜାଣିପାରିବେ ଭଏସ ଆଇଡେଣ୍ଟିଫିକେସନ ରୁ ଜାଣିପାରିବେ। ତ ବିଭିନ୍ନ ସୋର୍ସ ଅଛି ଏଗୁଡା କଣ ଆପଣଙ୍କୁ ସବୁ କହିବାକୁ ପଡିବ।
ଏଇ ସବୁ ଲାଗିଛୁ ସାବ ମତେ ଦେଲା ପରେ ମୁଁ ଲାଗିଛି ତା ସବୁ ତାପରେ ତ ଏଲୋ ଡ୍ୟୁଟି ସାବ ଦୁର୍ଗା ପୂଜାରେ ଗଲି ସବୁଆଡେ ଯେତିକି ସମୟ ମିଳିଲା ସାବ ସିନସିୟର ଷ୍ଟିପ୍ ନେଇଛି। ଆଉ କାଲି ବି ଯୋଉ ସେମାନେ ଝିଅର ବାପା ମା ଯୋଉ କହୁଛନ୍ତି ତା ଭିଣେଇ ତାଙ୍କୁ ଆଶ୍ରୟ ଦେଇଥିଲା ସେଠି ବି ସାବ କାଲି ରାତିରେ ଯାଇଥିଲି ରେଡ୍ କଲି ସେ କିନ୍ତୁ କୋଅପରେସନ କଲାନି। ତାର ସାନ ଭାଇ ସେଇ ଆକ୍ୟୁଜର ତା ପିସି ପୁଅ ଭାଇ ସେଠି କାମ କରୁଛି ଫର୍ଣ୍ଣିଚର ଦୋକାନରେ ତାର ଷ୍ଟେଟମେଣ୍ଟ ନେଇଛି ୱିଥ ଅଡିଓ ଭିଜୁଆଲ ମିନ୍। ସେ କହିଛି ସେ ଫର୍ଣ୍ଣିଚର ଦୋକାନକୁ ସେ ଆସିଥିଲା 2 ଜଣ ଯାକ ଆସିଥିଲେ ପୁଅ ଝିଅ ଏବଂ 21 ମସିହାରେ ସାବ ସେଟା
Oh,
ଆଉ ପଇସା ନେଇକି ଯାଇଛି ସାବ ବହୁତ ଲଙ୍ଗ ଟା ମତେ ଏବେ ଦିଆ ହେଲା 2 ମାସ ହେଲା। ମତେ ସାବ ସମୟ ଟିକେ ଦେଲେ ମୁଁ ନିଶ୍ଚିତ ଏଟା
No, it's all right too.
ସାବ
There is
if you're trying,
you're trying it's good but ଯୋଉ ଜିନିଷ ଗୁଡାକ କରିବା କଥା ତାକୁ ସ୍ପିଡ ଅପ୍ କରାନ୍ତୁ।
ସାବ
ହଁ
ସାବ
and constructive steps should be taken. You can file
Hmm.
requisition, as
ସାବ
my lord is saying. You can file requisition to see that even if you are not recording the voice, for the purpose of identification of the voice, you can make a requisition
right
and hear the conversation.
ସାବ
ସେଟା ଆପଣଙ୍କର ଗୋଟେ ପର୍ଟିକୁଲାର ପିରିୟଡ ପାଇଁ ଷ୍ଟୋର ହେଇକିନି ରହେ ଦ୍ୟାଟ ଇଜ ଦି ଇନଷ୍ଟ୍ରକ୍ସନ। ଯେତେବେଳେ ବି ଦରକାର ହେଲା କୌଣସି ପର୍ପସ ଅଫ ଇନଭେଷ୍ଟିଗେସନ ଯଦି ରିକ୍ୱିଜିସନ ଦିଆଯାଏ ସେମାନେ ଆପଣଙ୍କୁ ଆଲାଉ କରିବେ ଶୁଣିବା ପାଇଁ ଆପଣ ଯୋଉଥିରୁ ଜାଣିପାରିବେ। So it's not a ତେଣୁ ଆପଣ ରିକ୍ୱିଜିସନ ଦିଅନ୍ତୁ। ଆଉ କୋଉ ଜିନିଷ ହଉଛି we cannot make everything detail in the order because it's a secret thing. You
Yes.
do it
ସାବ
whatever you are
So,
doing. So we are just keeping a matter, we are adjourning. So whatever you are doing, please carry it, but do it speedily.
ସାବ
The so last order. Ma'am, your name is Srimati Sarojini Singh.
ସାବ ସାବ
Right. Srimati Sarojini Singh, DCP,
DSP.
DSP, 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 IUCAW, Jagatsinghpur. Is present. He has submitted with the investigating officer of the Ramchand Raghunathpur PS case number 45, dated 2/4/2021, is present, and she has submitted the status report and seek some further time to carry forward his her investigation and to take all effective steps to rescue the victim and to arrest the accused. Put up this matter in the second week of January 2024, date they given. The DSP shall remain present on the next date and apprise this court about the development made, if any, in the meantime, and shall also produce the up-to-date case diary. Okay, free copy of the order be handed over to the Land and Council for the state. এটা রকি দেবে।
Item number 5.
This is a missing report case, my lordship are directed to talk with the IIC. I have talked with the IIC. That missing report case is continuing, my lord. He has not yet been traced out. I have to.
What is the prayer made in the?
The daughter is the petitioner here. Father is missing, so he has filed.
Obhin Chandra Barik. But he stated that it was to be from the wrongful confinement of opposite party number 6.
But that is not correct.
Correct. Okay. Who is that opposite party number 6? So why he will?
He is the son and son of the this missing person.
Okay, okay. So that means the father is staying now with the son.
No, father is left somewhere. So
Okay.
daughter
But
is
he alleged that she alleged that the son has wrongfully confined the father. That was the allegation, but it is not that. Correct.
That missing report is still found.
But the husband of the petitioner is now missing, right?
Husband, father of the petitioner.
Father of the petitioner, daughter Abhinav Chandra Parik. That means petitioner and the OP6 are brother and sister. Okay.
What is the age of the person?
79 now.
17.
What when it was lost in
16.
16.
MAR number 40 of 2016.
Because after a few days that section will come into that if somebody doesn't, we suppose that 7 years that provision is there, so it is to be date,
Civil death.
So I think what is that section?
CPC.
No, there's evidence the persons who ordinarily is expected to hear about him, so if they have not
In and out.
107.
100 something. Okay.
But in order to get some benefit of it, you have to get a declaration.
Right, that is there.
108.
108.
Ah, 700 is there. But on
108.
that person is alive who has not been hard for 7 years. The question is whether a man is alive or dead, and it is proved that he has not been hard off for 7 years by those who would naturally have heard of him if he had been alive. The burden of proving that he is alive shifted to the person who affirms it. Ki କହିବ ଯେ ମୁଁ ଦେଖିଥିଲି ଆଜ୍ଞା ସେ ଅମୁକ ଜାଗା ଅଛି. So otherwise there's a declaration has to be made. That appropriate case is to be filed to declare that person as dead, that missing from this date, tried our level, but these are the documents. So, and obviously the police officials of that concerned police station, they are to be called for, and those documents are to be verified, and thereafter the yes, the kind ଦେଖିଲେ କଣ ଆଣିଛନ୍ତି? In this writ petition, the petitioner Bharati Rao has prayed for production of his father Avin Chandra Varik before this court from the wrongful confinement of opposite party number 6, Suresh Chandra Varik, who is her own brother and son of Avin Chandra Varik. The learned counsel for the state has produced the written instruction received from IIC Tangi Police Station dated 29/11/2023, wherein it is mentioned that on the basis of a missing report submitted by the petitioner at Tangi Police Station on 17/12/2016, Tangi PS SDE number 6 dated 17/12/2016 oblique MMR number 40 of 2016 was registered, and local inquiry has been conducted, but the missing person, Abhinav Barik, could not be traced out till now. The learned counsel for the state on instruction submitted that the averments taken in this writ petition that Abhinav Chandra Rao Barik has been wrongfully detained by the opposite party number 6, Suresh Chandra Barik, is not correct. And since it's a case of missing person and there is no illegal or wrongful confinement of the Abhin Chandra Barik by anybody, this writ petition is not maintainable. In view of the settled position of law, so and so keep those decisions. Since it's a case of missing person, we are not inclined to entertain this. We are not inclined to pass any further order in this writ petition. Accordingly, the writ petition is disposed of. This written instruction is taken on record for them. Any other passable matter? Oh, no,
Fantastic.
Item number 22.
yes. Please use the mic properly.
Yes. In the FIR, he has narrated a story, and in 161, a different story. I've gone through that, and
You sum up your argument.
Yes, ma'am.
We have already gone through all those evidence. What is your submission? Just sum it up, then we'll hear Mr. Misra.
yes, ma'am. Only one thing. that
Yes.
in the morning they, as per the FIR story, the mother and aunt came. Then they searched and dead body found. But the exact time was not mentioned, and at 4 o'clock that was FIR was registered as per FIR time.
No, FIR ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି
For next day, 4 o'clock.
After the body was found, the FIR was lodged.
ଏଇ ଯୋଉ ଲାଇନଟା ରହିଛି ଯେ ଗତ ମଙ୍ଗଳବାର 2/1/2007 ସନ୍ଧ୍ୟା ସମୟରେ ମୋର ଝିଅ ମମତା means the deceased,
Yes, ma'am.
ଜ୍ୱାଇଁ ପ୍ରମୋଦ is the appellant,
Yes.
ଆମ ଘରକୁ ଆସିଥିଲେ।
ଆଜ୍ଞା।
3 ତାରିଖ ଦିନ ଆମ ଘରେ ରହିଲେ। 4/1/2007 ସନ୍ଧ୍ୟାରେ ସେ ଦୁଇ ଜଣ କଣ କୁସୁମ ବାଟ ଯିବୁ ବୋଲି କହି ଚାଲିଗଲେ। ଆଜି 5/1/2007 ସକାଳ 6ଟା ହେବ ପ୍ରମୋଦର ମା କଣ ଗମାଲି ଡିଗଲ, she has not been examined,
No.
ଆମ ଘରକୁ ଆସି ପୁଅ ଝିଅ କୁଆଡେ ଗଲେ ବୋଲି ପଚାରିଲା। ମୁଁ ଗତକାଲି ସନ୍ଧ୍ୟାରେ ତୁମ ଘରକୁ ଗଲେ ବୋଲି କହିଲି। ସେ ଗାଁକୁ ଚାଲିଗଲେ। ମୋ ସ୍ତ୍ରୀ ସନ୍ଧ୍ୟାବତୀ ଡିଗଲ means again she has not been examined, ଓ ମୋର ଶାଲି ବନିତା ଡିଗଲ is PW5। ଗାଁର ଚାରି ପାଖେ ଖୋଜାଖୋଜି କଲୁ। That means informant along with this PW5 and of course his wife, he has not been examined। ଖୋଜିବା ସମୟରେ କୁସୁମ ବାଟ ରାସ୍ତା ଗୁମାପଦର ଗୋଟିଏ ଆମ୍ବ ଗଛ ତଳେ ରାସ୍ତା ପାଖରେ ମୋର ଝିଅ ମମତା ମରି ପଡିଛି। ତାର ବେକରେ ଧାରୁଆ ଅସ୍ତ୍ର ଦ୍ୱାରା କଟା ଚିହ୍ନ ଅଛି। ବହୁତ ରକ୍ତ ବାହାରି ପଡିଛି। ବେକରେ ପିନ୍ଧିଥିବା ଲୁଗାର କାନି ବନ୍ଧା ହୋଇଛି। ପ୍ରକାଶ ଥାଉ କି ମୋର ଜ୍ୱାଇଁ ପ୍ରମୋଦ ଡିଗଲ 4/1/2007 ତାରିଖ ସନ୍ଧ୍ୟାରେ ମୋର ଝିଅ ମମତା ଡିଗଲକୁ ତା ଘରକୁ ନେଇ ଯିବା ସମୟରେ ଗୁମାପଦରେ କୌଣସି ଧାରୁଆ ଅସ୍ତ୍ର ଦ୍ୱାରା ବେକରେ ମାରି ହତ୍ୟା କରିଛି। ପ୍ରମୋଦ ଡିଗଲ ମୋତେ ମମତାକୁ ଅନ୍ୟ କାହା ସହିତ this about this motive part, ପ୍ରମୋଦ ଡିଗଲ means the appellant ମୋତେ ଆଗରୁ ମମତାକୁ means deceased କୁ ଅନ୍ୟ କାହା ସହିତ ବାହା କରିବା ପାଇଁ ଠିକ କରିଛ କି ବୋଲି ପଚାରୁଥିଲା। ମୁଁ ତାକୁ ମନା କରିଥିଲି। ସେ ରାଗ ରଖି ମୋର ଝିଅକୁ ପ୍ରମୋଦ ଡିଗଲ ମାରିଥିବାର ବିଶ୍ୱାସ କରିଅଛି। ଏଣୁ ରିପୋର୍ଟ ଦେଇ ତଦନ୍ତ ହଉ। ତାପରେ ଆଉ ଗୋଟେ କଣ ଲେଖା ହେଇଛି, ହାତ ଡିଗଲ ହାତୀ ଡିଗଲ କହି ପକ୍କା ରିପୋର୍ଟ କରୁଛି। ରିପୋର୍ଟ ମୁତାବକ ଶୁଣାଇଛି। So is a scribe of the FIR. So obviously what Mr. Mishra says that after the dead body was found in that mango grove, the FIR was lost, right?
Almost.
And the deceased was seen alive on the on 4/11/2007 in the evening hour.
Yes.
And she left the house as per the FIR in the company of the appellant. Okay. Thereafter, nobody has seen her alive. Her dead body was found in the early morning in that mango in a condition where she has sustained injuries, particularly injury on the neck portion. So this is the FIR lodged by PW4. And PW4 has also supported this version in the evidence. Right? Just you come to page 42.
Yes, madam. My submission is that
Just read it. Come to paragraph number 2.
On 2/11/2007, both of them had come to our house. They stayed till 5 p.m. of 4/1/2007. Then they both left our house. Next day at 5 a.m., accused mother and aunt came to our house to inquire also where the accused and the deceased had been. I told that they left our home yesterday at 5 p.m. Then I entertained doubt. We went in search of my daughter inside Gumapadar forest, which is half kilometer from my house. I found dead body of my daughter lying near a mango tree. Her neck was found cut from front side. We went accused house. Accused father was present. None else was present. Accused was not there. We brought accused father to show him the dead body. I asked him to watch the dead body and went to Sadar PS to lodge a report. One Boykuntha Digal wrote a report as per my narration. Exhibit 4 is the report. Exhibit 4.1 is my signature. When
No, yes, leave that, but read paragraph number 5.
my elder daughter is given in marriage 2 years back in village Kainjara. Accused was reading in Tolapada High School. Deceased fell in love with the accused. She left my custody of her home and want to live with the accused. For 2 months, they lived together. During that period, they came to my house twice or thrice. On the day following the elopement of the deceased, we intervened and their marriage as per caste custom was solemnized. Accused father is deep. He is poor. I am also a poor. I do not know if the accused was having any income. It is not a fact that myself and my wife were not interested to give the deceased to the accused family. Then he volunteers. The accused parents were dissatisfied with the deceased marriage with the accused as we are poor. My house is 3 kilometers from accused village. There is only one road connecting my village and accused village, which is jeepable. There is another pathway through jungle. But to court, the accused and deceased took the pathway while they left my house together. Again says, I cannot say which route they took. It is not a fact that villagers go to the Gumapada jungle to attend call of nature. I did not accompany the accused and deceased to see them off. My wife was also in the house. She also did not see them off. It is not a fact that accused left my home on 4/11/2007 at 10 a.m. and my daughter, deceased, was not allowed to go with him, and that my daughter stayed with us in the night 4/1/2007. In our village, there are 16 houses with 40 to 45 population. The site where dead body was lying is not rocky, but its surface is uneven. I was not interrogated by the police. I have never narrated before others all that I have stated today. It is not a fact that I have not stated before the IO that the deceased and the accused together left our house on 4/1/2007 at 5 p.m. It is not a fact that I have stated before the IO the first accused left my home in the evening when my daughter refused to go with him, and sometime after departure of the accused, my daughter left home to attend call of nature, but she did not return in that night. It is not a fact that I stated before the IO that on 4/1/2007, when accused asked my daughter to go with him back to his home, my wife and my daughter did not agree despite of repeated persuasion by the accused. It is not a fact that since my daughter met untimely death and we are not happy with the accused financial position, we have alleged falsely that the accused and the deceased left my house together even though the accused left home at 10 a.m. on 10 a.m. On 4/1/2007, I had filed a 1cc case in the court of SDGM Fulwani against the accused, his mother, and his aunt. Further
No, this suggestion which you have given in paragraph number 7 to this PW4.
Yes.
You see, what is your suggestion that the accused, it is notified that the accused left the house and mane dino 10ଟା ବେଳେ ପଳେଇଲା.
Yes.
ହେଲା?
Yes.
And my daughter was not allowed to go with him.
Yes.
And that my daughter stayed with us in the night on 4/1/2007.
Yes.
That means your daughter did not go or lay even on that day. This is your suggestion which you have given. That this plea which you have taken, it is one kind of plea suggestions, and this plea has not been taken. Have you in your 313 statement? Your is total denial. In the 313 statement, nothing is there.
No.
So this suggestion which you have given, it is not also in consonance with that 161 also. 161 रे आपनकर केस कौन हला जे accused गला 5टा बेले deceased तापरे संध्या बेले गला to attend the call of nature फेरिला नहीं आपण सजेशन दउचंदी कोन जे से 10टा बेले पळेला तापरे राती सेति कि नुहे झियो आपनकर संग राती रे रहिला आपन सजेशन होची झियो ଆପଣ ପାଖରେ ରାତି ସାରା ରହିଲା ଆପଣ କହିଲେ ପରା ଦେଖୁନାହାନ୍ତି my daughter stayed with us in the night of 4/1/2007. So this suggestion has no meaning because the deceased was not there. The dead body was there, found in the next day. So is it not the suggestion or the defense plea which you have tried to take, is it not inconsistent? ଆପଣଙ୍କର statement ଆପଣ जो accused ର ଇଏ ନଉଛନ୍ତି ଗୋଟେ ପ୍ରକାର ସଜେସନ ଦଉଛନ୍ତି ଆଉ ଗୋଟେ ପ୍ରକାର ଆପଣ ସାଇଲେଣ୍ଟ ରହି ଯାଉଛନ୍ତି 313 ରେ, whereas what has been pointed out to you that even though in that 161 it is something different,
yes,
but right from the beginning, that means the FIR and this one court version, is it not consistent?
If even if a person is believable, the 5 p.m. dead body after 5 p.m. next day, they have searched. They have searched for the dead body, disease.
No, that you have not confronted with the IO. That you have been taking that is how you have been taking inconsistent pleas. What you have suggested to the witness has not been confronted to the IO.
Yes. So, that he has not left, and with the accused, that was that there he stopped, and others are left. That he has
ଆପଣଙ୍କର suggestion, it is all right.
Yes,
Defense is accused has a right to remain even mum. But ଆପଣ ଯେତେବେଳେ suggestion ଦଉଛନ୍ତି ଆପଣଙ୍କର ଯୋଉ plea ଟା put forth କରୁଛ ଆପଣ plea ଟା କଣ ଏଠି ଆପଣଙ୍କ plea ଟା ହଉଛି ଯେ ସିଏ ଇଏ ଆଗରୁ ପଳେଇଲା ଅର୍ଥାତ appellant ଆଗରୁ ପଳେଇଲା ସେ କଣ ସିଏ ଯେହେତୁ ରାଜି ହେଲାନି ଯିବା ପାଇଁ ଆଗରୁ ପଳେଇଲା ତାପରେ she left the house to attend call of nature, did not return. ଏହା ହିଁ ଆପଣଙ୍କର କେସ୍ ତେଣୁ ମୁଁ ତା ସାଙ୍ଗରେ ଯାଇନି ତେଣୁ ମାରିବାର ପ୍ରଶ୍ନ ଉଠୁନି ଏହା ହଉଛି ଆପଣଙ୍କର କେସ୍
କଲ୍ ଅଫ୍ ନେଚର ଟା ସେଇଟା ପଚାରି ନାହାନ୍ତି
କୋଉଟା ପଚାର
କଲ୍ ଅଫ୍ ନେଚର କୁ ଯାଇଥିଲା କି ରାତିରେ ଯୋଉ ରହିଗଲା ପରେ ତା ପରଟା ଖାଲି ସେଇଟା ରହିଯାଉଛି
କଥା
ସିଏ ସେଇଟାକୁ
କଲ୍ ଅଫ୍ ନେଚର ନାହିଁ ଆପଣଙ୍କର 313 ରେ ଆପଣଙ୍କର ସାଇଲେଣ୍ଟ ଅଲଗା ଜିନିଷ କହୁଛନ୍ତି ସବୁ ମିଛ କଥା ତେଣୁ
So virtually you have not set forth a defense plea.
Yes.
Although it was required from you because you were the person being the husband evidence is there that you
କାରଣ
have
ଆମେ ଯଦି accept କରିବୁ ସେଇ ଜିନିଷଟାକୁ, it was pointed out the other day that the deceased has left the house of her parents with you, then it is the requirement on your part, the burden of proof shifts on you, that you are to explain where how your wife made a homicidal death. The dead body was found in that road on the way to the house of the accused, and you also did not reach the destination because your family members came and searched for the both of them. Of course, they searched for both of them, and you are hiding in that jungle.
This also vouches the stand of the prosecution that in the C report, the wearing apparel of the accused is also stand with blood
Yes.
of human origin O group.
Yes, matches with the blood group of the
Right.
That was our High Court decision that was sent with the deceased garments. The accused find pant shirt.
No, it was
Parcel.
It means under one
One
fold or along with that.
along with that.
Now, how different exhibits are there? Different exhibits are
60
there.
64 that was in
ଆରେ ଆପଣ ଯୋଉ ମିଶେଇ ମାସେଇ ଦେଇକି ପଠେଇବା କଥା କହୁଛନ୍ତି, ତା ଦେହରୁ ରକ୍ତ ଆସି ଲାଗି ଯାଇଥିବ, ଯାହା ପଏଣ୍ଟ ଆଉଟ କରୁଛନ୍ତି ମିଟ୍ କରୁନାହାନ୍ତି।
64 page 64 ये फास्ट मेमो जो रिसीव करछन सेटा लेखा है
64
yes madam
हाँ
second the parcel consisted of one cardboard box which was enclosed with cloth cover, was sealed with impression of the seal corresponding to the seal impression forwarded. It contained exhibits A1 to E1 and as per details in forwarding report.
No, forwarding report ଟା ଆପଣ ଆଗେ ଦେଖନ୍ତୁ, ପ୍ରତ୍ୟେକଟାକୁ ଅଲଗା ଅଲଗା ମାର୍କ ହେଇକି ରହିଛି।
ମାର୍କ ହେଇଛି
Now that is how it is.
ଗୋଟିଏ ପାର୍ସଲ ରେ ପଠେଇଛନ୍ତି। That was the our high condition.
ବ୍ଲଡ୍ ଥରେ ଶୁଖିଗଲା ପରେ
ଆଣିଛନ୍ତି ସେଟା ଆଇଓଠୁ ଆଣିଛନ୍ତି, ଆଉ ତାହେଲେ ଗୋଟେ କ୍ରସ୍ ସେକ୍ସନ ଆସିବ ନା
ସବୁ ଜିନିଷ ଇମାଜିନେସନ ଆପଣ କେମିତି ପ୍ୟାକିଂ କଲେ କଣ କଲେ
ଏଇଟା put the question to the IO.
And you see the wearing apparels of the deceased were seized on the date of when that postmortem was conducted.
Yes.
The accused arrested at a later point of time.
That blood group was not detected accused. Not blood group.
ଆପଣଙ୍କର ପ୍ଲି ଅଛି କି ମୁଁ ଆଜ୍ଞା ମୁଁ ନିଜେ ଖଣ୍ଡିଆ ଖାବରା ହେଇଥିଲି, ମତେ ପିଟା ମରା କରିଥିଲେ, ମୋ ରକ୍ତ ହିଁ ୟା ଦେହରେ ଲାଗିଛି, ଆପଣଙ୍କର ପ୍ରଶ୍ନ ପଚରା ହଉଛି। ଆପଣ ପ୍ଲି ନ ନେଲେ ଆପଣ ଖାଲି କହିଦେବେ ମୋ ବ୍ଲଡ ଗ୍ରୁପ ଟା ହେଲା ନାହିଁ, ପରୀକ୍ଷା ହେଇନି, ତେଣୁ ହୁଏତ ସେ ଓ ଗ୍ରୁପ ଟା ମୋର ହେଇଥିବ ଆକ୍ୟୁଜ ର। ଆପଣ ପ୍ଲି ନେଲେନି, ଆଜ୍ଞା ମତେ ଯେତେବେଳେ ଧରିଲେ ମତେ ପିଟା ପିଟି କଲେ, ମୋ ଦେହରୁ ରକ୍ତ ବାହାରିଲା, ସେଇ ରକ୍ତ ଲାଗିଥିଲା।
କିଛି ମିଛ କରିଦେଇଛି,
ସବୁ ତ ମିଛ ଆଉ।
Or a simple suggestion also to the IO that yes, you mingled the clothes, and this could not have been the possibility of getting the blood sticking to the wearing apparel of the deceased could have been there. Some suggestion be also there. Out of nothing, a presumption, assumption, nothing will be.
Jury ka bhi ketekaro
କାର injury? Accused injury ଅଛି, yes, that is there.
ଟା କେବେକାର ବି ହେଇନି।
ନା that proximate
age of the I had not mentioned the age of the above injuries. ସେ ପଚରା
ଆଗରୁ injury ଥିଲା ବୋଲି ଆପଣ କେସ୍ ଅଛି କି? That is so without having any plea from your side, how can you?
SDC ରହିଛନ୍ତି। Accused statement has a purpose. That is why it is given at the end of the prosecution evidence all the incriminating material. जोटा भी no incriminating material जदि पचरा न होइतो that cannot be used against that is the law. तेणु आपन को opportunity आपन कहि परियो जे माया स्टेट डिफेंस काउंसिल थिला, मु काउंसिल थिले आपन ये करले ଆଉ ଡେଥ୍ ଟା ହେଇଛି ସେଇ ସମୟ ଭିତରେ ଆପଣ ଦେଖନ୍ତୁ 24 ରୁ 48 ଘଣ୍ଟା ଭିତରେ ପୋଷ୍ଟମର୍ଟମ ହେଇଛି ଆପଣଙ୍କର 6 ତାରିଖ ଦିନ ହେଲା ଆଉ 1:30 ରେ ହେଇଛି ମାନେ ଦିନ 1:30 ରେ ତେଣୁ ସିଏ କହୁଛି ପାରାଗ୍ରାଫ ନମ୍ବର 4 ରେ ଯେ 24 ରୁ 48 ଘଣ୍ଟା ମାନେ 24 ଘଣ୍ଟା ଟାକୁ ଏକ୍ସକ୍ଲୁଡ କରିଦିଅନ୍ତୁ ଅର୍ଥାତ୍ 5 ତାରିଖ 1:30 ଭିତରେ ହେଇନି ଦିନ 1:30 ତା ପୂର୍ବରୁ ହେଇଛି ଏବଂ 4 ତାରିଖ ଦିନ 1 ରୁ 5 ତାରିଖ ଦିନ 1 ଭିତରେ ହେଇଛି 24 to 48 hours. Okay, this one is about the last scene, number 1. Number 2 is the your motive is there. Of course, you say that there are different type of motives have been put forth. ଏଠି ହେଲା ଯେ ଗୋଟେ ହଉଛି ଯେ ଝିଅ ରାଜି ହେଲାନି ବା ସେ ବାପା ଘର ରାଜି ହେଲାନି ତା ସାଙ୍ଗରେ ଛାଡିବାକୁ ଆଉ ଗୋଟେ ତାଙ୍କର
ପ୍ୟାରେଣ୍ଟସ୍
ପୁଅର ଥିଲେ
ଡାଉରୀ ପାଇଁ
dowry ପାଇଁ but and the next thing is your absconding, concealing yourself inside the jungle and that bloodstain jota ki group milila same group of the and knife of course knife रे blood kichi andani but
searching of their family members.
So any citation etc you want to place, please place.
Yes, Mr. Mishra, you can make your submission to see that the prosecution case gets more robust.
Lordship. Lords, I'd just like to add 2 more circumstances. Lordship stated 5 circumstances. Lords, one is that no reasonable explanation was given by the accused in the 313 statement, which can be taken as a link to cover up the chain of evidence, Your Lordship. And another one is that the injuries on the body of the accused were not explained by him at all when he was posed that question, Your Lordship. And in fact, those injuries were of a very mild aberration in nature, Your Lordship. So my learned friend's submission that the blood stain in the apparels of the accused could be of the accused holds no ground here, Your Lordship.
Who is the doctor who examined the appellant?
PW9, my Lordship.
What sort of injuries he has noticed from the
Lordship.
PW9?
Abrasion size
2 into 1 cm.
Over the lip to the left side, and another abrasion to the over left side of the nose.
So both of them are very small and mild in nature.
ପଡିକିନି ମଧ୍ୟ ହେବ ବୋଲି ହେଇପାରିବ ବୋଲି କହୁଛି ସେ।
Yes.
So
Absence of a flip.
and also injuries are possible during a tussle with a human. Injuries are also possible by swan, so fingernail during tussle. Injuries are possible by
Broken
piece of glass bangles during swan. So there is no wanted swan. So by mistake I had mentioned the date was okay. I was transferred. I handed over. He has not stated about the age of the
Age he
injury.
has not stated. The likelihood of these injuries leaving blood patches on wearing apparel is extremely less likely, Your Lordship. Because as per Modi's jurisprudence, it has been clearly stated in the chapter of abrasions that abrasions bleed very slightly. So therefore, for abrasions on a nose and the lip to fall over the body, it has to be an extremely deep cut, Your Lordship, not a 3 into 1 cm and a 2 into 1 cm very small cut.
Full pant ଆଉ ଆର ଆସିଲା କଣ ଗୋଟେ ଆସୁଛି
Full shirt and full pant, Your Lordship. And so far as my learned friend's submission that because they were sent in the same box, the stains could have been transferred. Lordship, the forwarding report is on 29/3/2007. There is a gap of almost 3 months, my lords. So by that time, the blood would have already soaked up and dried. So even if they were sent in the same box, the likelihood of them transferring to the clothes of the wearing apparels of the accused is extremely unlikely.
The whole thing is that it should have been asked that in what condition, if you are taking that plea, IO might have also covered it, each of the clothes. ହେଲା ତାର ଆ ଶାଢୀ ହୁଏ ତ ସେ ଅଲଗା ସେପାରେଟ ରାପ୍ କରିକିନି ତା ଦେହରେ ମାର୍କ କରିଥିବ ଏକ୍ସିବିଟ୍ ଏଇଟା ହଉଛି ଏଟା ଅର୍ଡିନାରିଲି ହୁଏ
unless you have put question presumption is that it is each of the exhibits are separate to each other.
So according to Mr. Mishra, what are these 5 circumstances you said? 3 is there, that one is that last scene.
Yes.
The other is the motive.
Yes, Lordship.
Then the third is the bloodstain clothes.
Lordship.
And recovery of that knife.
Knife.
Of course, no blood is found. That is
Injury on the
injury. And then you say that no explanation from the okay.
And he was absconding.
And absconding.
These are the 7 circumstances there. And so far as the discrepancy between the 161 statement is concerned, like my lordship pointed out on the last occasion, the weightage has to be given to the FIR mode because that is the first instance in which the crime is reported. And there was no time even for embellishment. It was immediately reported after the dead body was found. So the 160
when this statement of this PW Force 161 when it was recorded, এটা ট্রায়াল কোর্টে এটা ভাগ করলে নাই সেটা নয় আচ্ছা হ্যাঁ সেইটা তাই পাই কেস ডায়েরি PW4 না কোন হলা
Hardy Digger.
You see, let us come to the first page of the yes Hardy Digger gist of the FIR পরে সিধা লেখা ହେଇଛି examination of তা মানে FIR দিয়া ହେଲା ସାଙ୍ଗେ ସାଙ୍ଗେ ସେ examine ହେଲା ହେଲା and so promptitude ରେ ହେଇଛି ତ FIR version ଯଦି ଗୋଟେ ପ୍ରକାର ଆଉ 161 ଯଦି ଗୋଟେ ପ୍ରକାର କହିଥିଲା ତାହେଲେ it was the duty of the investigating officer also to record the statement, make a prayer for recording the 164 statement. ହେଲା কিন্তু because this 161 is under his control, you can't so this query that statement. Let us see that again.
ସେଇଟାରେ ଯୋଉ ଡାଉଟ୍ ଅଛି 1cc କେସ୍ ଯୋଉ କ୍ୱେଶ୍ଚିନ୍ ଟା ଗୋଟେ ପଚାରିଥିଲେ ସେଟା ବୁଝି on last 45 page ରେ I had filed 1cc case in the court of SDGM Fulbani against the accused, his mother and his aunt. I think initially he has lodged FIR against 3. Then shifted to FIR 161 might be recorded fast, for which he has said that. 1cc case re accused and his mother and aunt. Last खाली गोटे क्वेश्चन पचारछन सेडा बोली I had filed a 1cc case in the court of SDGM Fulbani against the accused, his mother and his aunt. Might be he has lost the first
Page number
45.
45.
It is not a fact that I have
Your Lordship, the first line.
last line.
I
It is a fact. I have on 412. I had filed a so and so against the accused mother and so and so. What do you mean to say that?
First, initially he has complained and that accused mother and aunt and accused the
अरे 4 तारिख पर डिसीज तो मरी नथिला बोली जान नथिला सेटा आपण
डेड बॉडी पाइला परे
पाइला पर 5 तारिख पाइला 4 तारिख रे जो कंप्लेंट पिटिशन टा सेटा केमती सेही कनेक्शन नै दिबो
कंप्लेंट माने होची सेटा
मे बी some other
सेटा रे मत
Those are also two different sentences, my lords. Lordship may see that 10 a.m. is 4/1/2007 is the completion of the previous statement.
Previous statement. I had filed tapore.
Accused left home at 10 a.m. on 4/1/2007. Tapore next statement is I had filed. So these two statements are not conjoined together at all. So 10 a.m. for a dot rahi jaichi. That's why O has been made.
It's not about that since my daughter made untimely death and we are not happy with the accused financial position. We have alleged falsely that the accused and the deceased left my house together even though the accused left home at 10 a.m. on I think he is right. Acha, I had filed a 1cc case so and so against the accused mother. A 1cc case कौन थेरा?
1cc was 161 taku pacharchandi 1cc. Oh, he has first. I have think that after dead body found, he has lodged against complaint against the complaint against accused his mother and aunt. Then he
kept time ଆପଣଙ୍କର ପରା 5 ତାରିଖ ସକାଳୁ 5 ତାରିଖ ସକାଳୁ ଡେଡ୍ ବଡି ମିଳିଲା
ଏଇଟା ତ ଅଲଗା ପୁରା କ୍ୱେଶ୍ଚିନ୍ ଟା ଅଲଗା ହେଇଯାଇଛି ସେଟା ଡେଟ୍ ଟା ଦେଇନାହାନ୍ତି
ତାର କଣ
ଭାବୁଛି ଯୋଉ ଡିଫରେନ୍ସ ହେଲା ସେଇଟାର
ନାଇଁ ଏ କମ୍ପ୍ଲେଣ୍ଟ କେସ୍ ଟା କଣ ପାଇଁ ଫାଇଲ କଲା କେବେ ଫାଇଲ କଲା ସେ ଖାଲି ଆପଣ ଏଇ ଲାଇନ ଟାକୁ ଯଦି ସେପାରେଟ ପଢିବେ ସେ କହୁଛି ଯେ ମୁଁ ଗୋଟେ କମ୍ପ୍ଲେଣ୍ଟ କେସ୍ ଫାଇଲ କରିଥିଲି ଏସଡିଜିଏମ ଫୁଲବାଣୀରେ 3 ଜଣଙ୍କ ନାଁରେ ଏଇଆ ବାସ୍
ସେଇଟା କମ୍ପ୍ଲେଣ୍ଟ କରିଥିଲା ବୋଧେ ସେଇଟା କହିଥିବ 1cc ହେଇଯାଇଛି
କି କମ୍ପ୍ଲେଣ୍ଟ କଣ କେବେ ଫାଇଲ ହେଇଛି
ଫାଷ୍ଟ କମ୍ପ୍ଲେଣ୍ଟ କରିଥିଲା 3 ଜଣଙ୍କ ନାଁରେ ତାପରେ ସେ ନାଇଁ
no connection no you cannot just you are stretching it to such a level there is nothing on that complaint petition ଆମ ପାଖରେ ନାହିଁ question ନାହିଁ ସବୁ ଜିନିଷ ଆପଣ ଷ୍ଟ୍ରେଚ୍ କରିକି ନେଇ ଯାଉଛନ୍ତି ଯେ ପ୍ରଥମେ ଆଗେ 3 ଜଣଙ୍କ ନାଁରେ ଦେଇଥିଲା ତାକୁ ଛାଡିକିନି ତାପରେ ଏଫଆଇଆର ଜଣଙ୍କ ନାଁରେ ଦେଲା କୋଉଠୁ ପାଇଲେ ଗୁଡା
ଖାଲି ଡିଫରେନ୍ସ ଟା ଯୋଉ ହେଲା 161 ପୁରା ଡିଫରେନ୍ସ
then in that case complaint petition ରେ ଯଦି ଆପଣଙ୍କୁ accused କଲା
for my argument not that was ଖାଲି ଡିଫରେନ୍ସ କଣ ହେଲା ସେଇଟା ବୋଧେ
you are constructing a castle without a foundation
କିଛି ହଁ କେସ୍ ଟା ଡେରିରେ ହେଇଥାନ୍ତା 4 ତାରିଖରେ ସନ୍ଧ୍ୟା ବେଳେ ଘଟଣା ହେଲା ମାନେ କେହି ଦେଖିନାହାନ୍ତି କେମିତି ମର୍ଡର ହେଲା 5 ତାରିଖରେ ମାନେ ଡେଡ୍ ବଡି ମିଳିଲା ସକାଳୁ ଏବଂ 5 ତାରିଖ ଦିନ ହିଁ ଏତଲା ଦିଆଯାଇଛି
ଡିଫେନ୍ସ ପାଇଁ କହୁନି ସେ କହୁଛି ଡିଫରେନ୍ସ ଯୋଉ ହେଲା ଏଠାର 161 that was
so you have given those citations
on last one 2014 for SCC 75 on last seen theory and motive even if the conviction of appellant cannot be maintained merely on suspicion however strong it may be or on his conduct.
You are placing which decision?
2014 for SCC 715. Here in this case, this is has gone to the appellant and bring some wine and the appellant and this is gone. Then in the morning, dead body was found in the appellant's well. Last seen theory and motive. Last seen theory, ସେଇଟା decide ହେଇଛି. Lights.
କୋଉ paragraph ହେଇଛି? ଯୋଉ last seen କହୁଛନ୍ତି which paragraph? If it is a solitary basis of this one to last seen acha. Paragraph number 11.
Yes, madam.
The primary, if not the solitary sworn so, as the deceased along with the accused
Kala
Kanayala visited the house of PW4 Kurma on at 9 p.m. On 31/8/2003, PW4 did not fully support the prosecution case and was declared hostile. In the examination in chief, he stated that on the date of occurrence night, he returned home at 8 p.m. and at about 9 p.m., accused Kanhaiya and Kala came to his house and demanded daru, and he gave one bottle and received so and so from accused Kanhaiya, and then they returned together. And on the next the morning, the wife of Kala, PW10, so and so came and inquired about her husband Kala, and he told about the visit of Kala with the accused Kanhaiya to his house in the previous night. It is the testimony of PW10 that her husband did not return home on the night of the occurrence, and in the morning she went to the house of PW Kurma and inquired and came to know from him about the visit of her husband along with Swanso to his house in the night. Though PW4 Huma was treated as hostile witness, the above testimony of him is corroborated by the testimony of PW10. Okay. The circumstance of last scene does not by itself necessarily lead to the inference that it was the accused who committed the crime. There must be something more establishing connectivity between the accused and the crime. Mere non-explanation on the part of the appellant in our considered by itself cannot lead to this one. So
This is the only circumstance.
So
motive was also there. That was
the alleged intimacy between the accused Kanhaiya and Kalmi so is said to be the cause of the occurrence. According to PW3, his wife Kamli left 4 years back and is residing with her parents and so on. So PW10 Shanti Bai also in her testimony has confirmed that Kamli has been living in village Sancheya for 5 years. It revealed that they were not living together for a number of years. The further testimony of PW3 that he has never seen Kalmi and accused Kanhaiya together, and no person in the village told him so, and it was his brother Kala who informed him about the illicit intimacy between them. By this context, it is relevant to point out that the wife of Kala, namely PW10 Swanson, in her testimony has not alleged any illicit relationship between Swanson. In this circumstance, it is doubtful as to whether there was any illicit Swanson. Further, hypothetical dispute Swanson.
On para 15, the court is saying that is the singular circumstance.
motive
Last scene is the singular circumstance. The court is
cordial relationship thila bole motive ta ko discard kar de ki last scene ta put here
that means the only circumstance. Here, other circumstances are there too. Is the singular piece of circumstantial evidence available against him? The conviction, definitely.
Okay, what about the other two?
Other two is blood patch bar.
Blood patch.
Actually, body appellant pant shirt. 2021 18 81 years 37 para
Who paragraph ta kuchanti?
The
last circumstance taken it.
8.3 re page 679 last paragraph. The planet
You see, that case that was relied upon, that Lakshmi Jani's case, the Justice B.K. Bera's decision. So here, the moment it is separately marked as an exhibit, it presupposes that it has been packed, and in the top portion, one exhibit has been given, that exhibit A.
Yes.
এইটা হচ্ছে exhibit A, এইটা হচ্ছে exhibit B. ତେଣୁ ଯଦି ସେଇଟା ନଥାନ୍ତା ଆପଣ କହିଥାନ୍ତେ ଅଲଗା କଥା, ଯେ ତାକୁ ମିଶେଇ ମାସେଇ ପଠେଇ ଦେଲେ କଣ ହେଲା। ତେଣୁ exhibit ତାକୁ ପ୍ୟାକ୍ ହୁଏ, ପ୍ୟାକ୍ ହେଇକି ଗୋଟେ exhibit ଦିଆଯାଏ, ତାପରେ forwarding report ପ୍ରିପେୟାର ହୁଏ, କୋର୍ଟ ସାମ୍ନାକୁ ଆସେ, ଦେଖାଯାଏ, ତାପରେ କୋର୍ଟରେ ମାଜିଷ୍ଟ୍ରେଟଙ୍କ ସାମ୍ନାରେ ତାକୁ ଇଏ କରାହେଇକିନି ପ୍ୟାକିଂ ହେଇକିନି କୋର୍ଟର ସିଲ୍ ସହିତ ତାପରେ କୋର୍ଟର ସିଗ୍ନେଚର ରହିବ ସେ ଫରୱାର୍ଡିଂ ରିପୋର୍ଟରେ। ଏଥି ମଧ୍ୟ ଅଛି ସେଇ ଜିନିଷ, ଏସଡିଜିଏମଙ୍କର ବା ଯିଏ ଜେଏମଏଫସି ତାଙ୍କ ସିଗ୍ନେଚର ରହିଥିବ, ପଠା ହେଇଥିବ। ତେଣୁ you see this signature and seal of the SDGM is there in page number 63. କାରଣ ତାଙ୍କରି ସାମ୍ନାରେ ମାଜିଷ୍ଟ୍ରେଟ ନିଜେ ଭେରିଫାଏ କଲା ପରେ ସେଇ ସିଲ୍ ଦେଇକିନି ପଠାନ୍ତି। ଏବଂ ଲାଷ୍ଟକୁ ଲେଖା ହେଇଛି ଦେଖନ୍ତୁ, certified that the director so and so has the authority to so and so send, and if necessary to take piece of exhibits from the same. ଏବଂ parcel consisted of one cardboard box which was enclosed within cloth cover, was sealed with this impression of the seal corresponds to the seal impression forwarded. ଗୋଟେ ସେପାରେଟ impression forward ହେଇଛି, ଯୋଉଟାକୁ ସେ ମଧ୍ୟ ସାଇଣ୍ଟିଫିକ ଅଫିସର ଭେରିଫାଏ କରିଛନ୍ତି ଯେ ଏଟା ମ୍ୟାଚ୍ କରୁଛି ବୋଲି, କାର୍ଡବୋର୍ଡରେ ଯୋଉ ସିଲଟା ଅଛି ସେଟା ମ୍ୟାଚ୍ କରୁଛି। So that rules out possibility of
Other
any
exhibits to have
tampering with the that clothes. କାରଣ ବେସ୍ ଥିଙ୍ଗ ଗୁଡାକ ଯୋଉଡାକ ଆଇଓ ଜେନେରାଲି ତାର ସେ ଯାହା କହିବା କଥା କହିଦେଇ ଚାଲିଗଲା, ଯେମିତି ମୁଁ ସିଜ୍ କଲି, ଇଏ କଲି, ସେ କଲି। ଆପଣ ଯଦି କୌଣସି କ୍ୱେଶ୍ଚିନ୍ ପଚାରୁଛନ୍ତି ଯେ ଏଇଟା ସିଲ୍ ହେଇନି, ସେଟା ମିଶି ହେଇନି, so that question to be କି ଇଏ witness ଟା delayed examination ହେଇଛି, all those questions are to be put to the IO so that he can ଆପଣ ନ ପଚାରିକିନି ଆପଣ you can 2 ଦିନ ପରେ ସେ ମନେକର ହେଇଛି, ସେ କେସ୍ ଡାଏରୀରେ ଏକ୍ସପ୍ଲେନ କରିଥିବ କଣ ପାଇଁ 2 ଦିନ ପରେ ଲ ଆଣ୍ଡ ଅର୍ଡର ଥିବ କି ଆଉ କୋଉ କେସରେ ଥିବ, ତେଣୁ ଖାଲି 2 ଦିନ ପରେ ଆଜ୍ଞା ହେଇଛି ତେଣୁ disbelieve କରିଦିଅ। So that is why it has been held that merely because a witness is examined after 2 days, that cannot be a ground that maybe that witness was not available. ତେଣୁ ୱିଟନେସ୍ କୁ ପଚାରିବାର ଆଜ୍ଞା ଅଛି ଯେ ତମେ ପୋଲିସ ଆସୁଥିଲା, ତମେ ଗାଁରେ ଉପସ୍ଥିତ ଥିଲ, ପୋଲିସ ପାଖରେ ଥିଲ, ଏଇ ଜିନିଷ ଗୁଡା ଇନଭେଷ୍ଟିଗେଟିଂ ଅଫିସର କୁ ମଧ୍ୟ ପଚାରିବାର ଅଛି ଯେ କଣ ପାଇଁ ତମେ ତ ଯାଉଥିଲ ଗାଁକୁ, ଅନ୍ୟାନ୍ୟ ସବୁ କରୁଥିଲ, ତମେ ଖବର ପାଇଲେ ତାର 2 ଦିନ କଣ ପାଇଁ ତାର ଇଏ କରୁଥିଲ ଯେ you have this was not, you have set up this witness as an eyewitness, that is why you are marking time to introduce the eyewitness. So see, all these things are to be specifically opportunity ଦେବେ ନା, ଆପଣ ତା ପଛରେ କିଛି ନ କରିକି ଖାଲି ନେଇଯିବେ आपण केमिति बर्तमान आमे नॉर्मल जेहेतु एगुडाक सब एग्जिबिट मार्क हेची it presupposes that it has been packed separately and the exhibit number has been given on the top of that packing. So आपण जदि कहबे आज्ञा मिसी मासी गला तो पचारथिबे आपन एटलीस्ट गोटे सजेशन दबार थिला ना नाही जे ना आपण सबु मिसी मासी किनि पठेई देले सेही पई ए रक्त से रक्त को पड़थला तो किछि नाही आपन accused केबे अरेस्ट हला
7/1/2007 3 दिन पर
सो पोस्टमार्टम हेगला 5 तारिख दिन
यस
5 तारिख दिन तारो
6 तारिख पोस्टमार्टम
6 तारिख हला नहीं डेथ हेची 4 तारिख दिन रात 5 तारिख दिन डेड बॉडी डिटेक्ट हेगला 6 तारिख पोस्टमार्टम हला 7 तारिख अरेस्ट हला सो देयर इज सफिशिएंट टाइम गैप बिटवीन तेणु ब्लड स्टेन आर गोटे ब्लड रही सेटा ड्राइड अप कंडीशन रे सेटा अन्य गोटे ताकू पड़ई जीवो सेथरे एवं आपनकर आपण आपण बर्तमान कोन प्ली नउछन जे डिसीज रो रक्तटा जोटा ता साडी रे लागतिला बा सेटा पड़ई थिबो
तापर ब्लड ग्रुपिंग ता हेनी
ता माने आधियर जेतेबेले ता माने सीज हेइथिला ताल तो ब्लड लागी न थांता ता आधियर टोटल ब्लड लागिनी एथुरु पड़ईची but you will find from the seizure list of the wearing apparels of the accused that there was blood stain. So
when it was seized, it was blood stain. So in that case, burden again is on you to explain.
Either आपण कहबे जे मो ब्लड ये लागिथिला बा केमति हला आपण एक्सप्लेन करियो. So this is that decision number 2. आउडा कोन डिसीजन दोचंदी
106 पर जोड़ा हस्बैंड वाइफ जे बर्डन शिप करियोनी जते पर्यंत
डिस्चार्ज करियोनी प्रिलिमिनरी प्राइमरी डिस्चार्ज
हां प्राइमरी सी जिंस सेगुडा को जे पर्यंत से माने प्रमाण करिना त आपण को बर्डन आसीगर प्रश्न नै से बेस गुडा को जिंस जोडा दरकार सेति को प्रमाण करिले बर्डन शिप लाइक जो एग्जांपल्स गिविंग दैट स्वामी स्त्री आगे से माने लास्ट सीन टा को आनिबे सेही घरे तापरे सेही घरु डेड बॉडी मिलला होमिसाइडल डेथ एई सब आनिला परे राती रे स्वामी स्त्री गोटे रूम रे थिले तापर दिन स्वामी एब्सकॉन्डिंग कला डेड बॉडी मिलिला होमिसाइडल डेथ देन क्वेश्चन इज किए मारला तापरे बर्डन शिफ्ट करियो तो बेस सीन जदी नथिबो ते एकाठी जदी राती रे ही नथिबो एविडेंस जे माने सी एक्यूज्ड हाउस डिसीज्ड एकाठी थिले बेली देन अदर थिंग्स ऑब्वियसली डजंट अराइज तेनु से मानकु प्रथम जिंस गुडाक आगे प्रमाण करिया पड़िबो. So anything else you want to?
That's all.
Heard Mr. Pulokesh Mahanti, land counsel appearing for the appellant. आपण एटार म ये ब्रीफ तो माने बदे माने पर्सनल माने नॉट दैट माने लीगेडेड दुहे तो हां ठीक है. एंड मिस्टर सोनक मिश्रा लैंड एडिशनल स्टैंडिंग काउंसिल land and counsel for the appellant filed some decisions which are taken on record. Hearing is closed, judgment is reserved. So this is item number
22, my lords.
22.
Lordship.
Yes.
Item number 23.
Yeah.
There are 4 accused persons faced trial and 3 has been acquitted. The present appellant is convicted under section 302.
Okay, please come to the FIR. Let us know that. What is the process.
32 page.
Yes.
ମୁଁ ଶ୍ରୀ ପ୍ରମୋଦ ନାୟକ ପିତା ଆଜି ତା 22/8
PW କେତେ?
PW 9
million.
Pramod Naik is PW 9. Okay.
Yes.
22/8/2013 ଦେବା ଲିଖିତ ରିପୋର୍ଟ ହେଇକି ଯେ ଆମ ଗ୍ରାମରେ ମଦ ବନ୍ଦ କରିବା ପାଇଁ, ଜୁଆ ଖେଳ ବନ୍ଦ କରିବା ପାଇଁ ଓ ଅନ୍ୟାନ୍ୟ ଭଲ କାମ ପାଇଁ ଗ୍ରାମରେ ଏକ କମିଟି କରିଛୁ। ମୁଁ ସେଇ କମିଟିର ଜଣେ ସଦସ୍ୟ। ଗତକାଲି ସନ୍ଧ୍ୟାବେଳେ ଆମ ଗ୍ରାମର ଚିତ୍ର ନାୟକ ପିତା ଉଦ୍ଧବ ନାୟକ ଟିବୁ ବନ୍ଧ ଛକ ପାଖରେ ମଦ ବିକ୍ରି କରୁଥିବା ଜାଣି ମୁଁ ଯାଇ ତାକୁ ମନା କଲି।
Chitra Naik means appellant.
ଏଥିରେ ରାଗି ଯାଇ ଚିତ୍ର, ତାର ମାମୁଁ ପ୍ରବାସୀ ଆଉ ଗୋଟେ ଆକ୍ୟୁଟ
जी acquittal ହେଇଗଲା। ट्रायल ये ट्रायल फेस କରୁଥିଲା ତ ପ୍ରବାସୀ। ହଁ ପ୍ରବାସୀ ट्रायल फेस କରୁଥିଲା acquitted। ଓକେ। ଚିତ୍ର ଶଳା ବସନ୍ତ ତ ଫେସ୍ କରୁନଥିଲା ଟ୍ରାଏଲ। ନାଇଁ ଟ୍ରାଏଲ ଫେସ୍ କରୁନଥିଲା ସେ ତ। ନା ୟେସ୍।
ଆଉ ମତେ ବାଡେଇବାକୁ ଆସିବାରୁ ମୁଁ ପଳାଇ ଆସିଲି। ଏହି କଥାକୁ ନେଇ ଆଜି ସକାଳ 7 ଘଣ୍ଟା ସମୟରେ ଆମ ଗ୍ରାମ ଦାଣ୍ଡରେ ମତେ ପ୍ରବାସୀ ନାୟକ ଫେସ୍ କରୁଥିଲା ଆଉ ଗୋଟେ ଆକ୍ୟୁଜ ମୋ ସହ ଝଗଡା ଲାଗିଲା। ମତେ ମୁହଁକୁ ମୁଥ ମାରିବାରୁ ମୁଁ ମଧ୍ୟ ମାରିଲି ଓ ଆମ 2 ଜଣଙ୍କ ଝଗଡା ଦେଖି ଚିତ୍ର ନାୟକ, ଭାସ୍କର ନାୟକ,
ଚିତ୍ର ନାୟକ is the appellant. ଭାସ୍କର is another accused.
ଓ କୈଳାସ ନାୟକ
Kailash Naik is also an accused who has been acquitted.
ଗଣ୍ଡଗୋଳ ପାଇଁ ତାଙ୍କ ଘରୁ ଠେଙ୍ଗା ଘଡିସା ଧରି ଆସୁଥିବା ବେଳେ ମୋ ବାପା ଆନନ୍ଦ ସହ ଚିତ୍ର ଆମ ଗ୍ରାମରେ ହରିଜନ ସାହି ରୋଡରେ ଥିବା ନଡିଆ ଗଛ ମୂଳେ ଝଗଡା ଲାଗିଲା। ତାପରେ ଭାସ୍କର ଓ କୈଳାସ ଚିତ୍ର ସହ
Ananda is the deceased in this case.
Yes.
All right.
ଭାସ୍କର ଓ କୈଳାସ ଚିତ୍ର ସହ ମିଶି ଝଗଡା କଲେ। ପ୍ରବାସୀ ମତେ ଛାଡି ଚିତ୍ର ସଙ୍ଗେ ମିଶି ସେ 4 ଜଣ ମୋ ବାପାଙ୍କୁ ଆକ୍ରମଣ କଲେ। ଚିତ୍ର ଧରିଥିବା ଘଡିସାରେ ମୋ ବାପାର ମୁଣ୍ଡକୁ ଓ ପରେ ଛାତିକୁ ଭୁଷି ଦେଲା। ଏଥିରେ ରକ୍ତାକ୍ତ ହୋଇ ବାପା ସେଇ ନଡିଆ ଗଛ ମୂଳେ ଟଳି ପଡି ମରିଗଲା। ଏଣୁ ଏହି ରିପୋର୍ଟ ଦେଉଛି କି ଏହା ଉପରେ କାର୍ଯ୍ୟାନୁଷ୍ଠାନ ହେଉ। ମୁଁ କହିବା ପ୍ରକାରେ ସରପଞ୍ଚ ଲିଖିଥିବା ଜାଣି ସନ୍ତ କଲେ।
Okay, who are the eyewitnesses to the occurrence?
PW 9 and 15.
PW 9 and PW 15.
Yes.
Both these eyewitnesses have been believed by the learned trial.
Yes.
Okay. So you come straight to the evidence of these 2 witnesses.
PW 9.
PW 9.
Page 74.
Yes.
I know all the accused person present in the dock. The witness named all the accused person and identified them inside the dock. They are my co-villagers. Mrs. Ananda Naika is my father. I am the informant of this case. The occurrence took place on 22/8/2023 at about 7 a.m. morning in our village Dando. On the previous day of the occurrence, I came to know that the accused Chitra Naik was selling liquor at Tipu Bandha Chaka, which is situated at the end of our village. So I, being the member of village committee, went there and requested the accused not to sell liquor. When I requested the accused Chitranayaka not to sell liquor, the accused Chitranayaka, Basanta Nayaka, Pandava Nayaka, and Cheru Gowda quarreled with me there at Tipu Bandha. Thereafter, I returned to my house. On the next morning at about 6 a.m., on the occurrence day, all the accused persons came near to our house and quarreled with me. All of a sudden, accused Prabhasi Naik gave 2 to 3 fist blows on my nose. Thereafter, other 3 accused persons, namely Chitra Nayaka, Bhaskara Nayaka, and Kailasa Nayaka, surrounded me. At that time, my father Ananda Naik was coming towards me. Seeing my father, all the accused persons left me and rushed towards my father. At that time, the accused Chitranayaka was armed with Ghodisa and other 3 accused persons were armed with Lathi. Accused Chitranayaka assaulted my father by means of a Ghodisa on his head. As a result of my father fell down on the ground, and thereafter other 3 accused persons assaulted him by means of Thenga, Lathi. While my father was lying on the ground, the accused Chitranayaka stabbed the Ghodisa on his abdomen, causing bleeding injury. My father had sustained severe bleeding injury from his head. My father was attacked by the accused persons near a coconut tree in front of the house of Soma Naik and Vishnu Naik. Thereafter, the villagers came to the spot and seeing them, the accused persons fled away, taking their instruments. Immediately after the occurrence, my father died at the spot under the coconut tree. I requested our Sarapancha Uchchava Naik to scribe the affair. Accordingly, the said Uchchava Nayaka scribed the affair as per my instruction, and thereafter he read over and explained the contents thereof. And being understood the contents thereof, I put my LTI in the said affair on the village. Thereafter, I lodged the affair at Patapur police station on the same day at about 10 a.m. This is the affair marked as Exhibit 8. I also examined my.
I was also.
I was also examined by the doctor for my injury on police requisition. I had sustained injury on my nose and right shoulder. Cross-examination. At the relevant time, I was also examined by the doctor for my injury on police requisition. I had sustained injury on my nose and right shoulder.
Yes. No, why I stressed it, it is stated that the injured person's presence, it cannot be doubted.
Yes.
So,
yes,
this is one of the aspects for which, yes. Next, come.
Cross-examination. At the relevant time, I was the president of the village committee. There was also a written document to that effect. Police, during investigation of the case, has seized that document. In the said village committee, Kaliya Naik, accused Prabhasi Naik, Gopal Naik, and Debo Naik were also members. The village committee had authorized me to prevent selling of liquor in the village. I know Pandav Naik of my village. It is not a fact that on 21/8/2003 at about 7:30 p.m., myself being accompanied with Pandav Naik had been to Tipu Bandha to purchase liquor. It is not a fact that on the same night again I had been to Tipu Bandha to purchase liquor after borrowing ₹100 from one Raghunath Naik of our village, and that I purchased liquor for ₹2, and that when I offered ₹100 currency note, the accused Chitranayaka declined to receive ₹100 currency note as we had no change money, and that for that reason there was altercation between myself and the accused Chitranayaka. It is not a fact that I had not been to Tipu Bandha Chakop to prevent selling of liquor by accused Chitranayaka. It is a fact that accused Chitranayaka had lost his father during his childhood, and for that reason he was residing in her uncle's house at our village. It is a fact that prior to the incident, Panchayat election was held in our area. It is not a fact that I am strong supporter of Congress party and the accused persons are the supporter of Janata Dal. It is a fact that when accused Prabhasi Naik gave fist blows on my nose, I also assaulted him by fist blows. Immediately thereafter, I had not reported about the assault. It is a fact that prior to the occurrence, the accused persons had no dispute with my father. The place of occurrence is at a distance of 25 cubits from my residential house. When the accused person came near our house on the date of occurrence, my father was not there as he had been to watch the field of the villagers. I have not seen whether my father assaulted accused Chitranayaka in his Jagali body stick. It is not a fact that my father assaulted accused Chitranayaka on his head by means of Jagali body, causing severe bleeding injury on his head, and that I was trying to snatch Godisha from the hand of accused Chitra, which was pierced on the abdomen of my father. It is not a fact that immediately thereafter I embraced my father at the spot by abandoning the Godisha at the spot.
Abandoning the
Abandon.
Hmm.
It is not a fact that I have not stated in the affair and before the police that on the date of occurrence, all the accused persons had came near my house. It is not a fact that I have not stated before the police as well as in the affair that one Pandav Naik and one Cherugouda also caused disturbance on the previous night of occurrence when I prevented selling of liquor. It is not a fact that I have not specifically stated in the affair as well as before police that when my father was lying on the ground, the accused Chitranayaka stabbed Godisha on his abdomen and that other three persons assaulted him by means of thenga. On the date of occurrence, at about 9 a.m., police reached in our village. One Gramaraki had informed about the incidents to police. I lodged the FIR Exhibit 8 at the PS itself. It is not a fact that there is no endorsement in the FIR Exhibit 8 that Ushchava Naik scribed the FIR as per my instruction and thereafter he read over and explained the contents thereof to me. It is not a fact that I have not stated before the police that as per my instruction, Ushchava Naik scribed the FIR Exhibit 8. Patiguda Harijana Sai is consisted of 2 rows of houses situated either side of the village danda. The villagers have witnessed the occurrence. It is not a fact that I have never cried for help from any of the villagers when myself and my father were attacked by the accused persons. The villagers, namely Udaya Naik, Amar Naik, had come to the spot after the occurrence. Besides, other villagers had also come, but I cannot say their name. It is not a fact that the accused persons were inimically terms due to political party faction and that we have hoisted this false case at the behest of Sarpancha Ushchava Naik. It is not a fact that accused persons are not responsible for the death of my father, nor they have assaulted me on the date of occurrence.
Okay, the
Witness is also injured.
this witness is an injured witness.
Yes.
And he has stated if we come to the assault part at page number 75.
Yes.
So see how many blows have been given to him. That is in the, it starts in the third line, na? At that time.
At that time,
At
the
that
accused
time.
Chitra was.
Chitranaik means the appellant was armed with
Odisha.
Odisha. Other three injuries were other three accused persons
Armed
who have
with
been acquitted. They are armed with lathi, but thenga. Then you read it.
accused Chitra Naik assaulted my father by means of Odisha on his head,
Okay, number one blow. Next.
fell down on the ground, and thereafter other three accused persons assaulted him by means of thenga, lathi.
Yes. Then
While my father was lying on the ground, the accused Chitra Naik stabbed the Odisha on his abdomen, causing bleeding injury.
so you have given two blows, one on the head, the other is on the abdomen portion,
Stabbed injury.
and stabbed wound. The other accused persons assaulted
By lathi.
This is by lathi. The doctor is PW 2. Come to that page number 56.
Yes.
Please, read it.
Read it.
On 28 2003, I was working as lecturer in FMT department, MKCG Medical College, Barampur. On that day at 4:50 p.m., I conducted PM examination over the dead body of Ananda Naik and found the following external injuries. One is lacerated wound of size 5 cm to 1.5 cm, scalp deep, placed her longitudinally on the right front parietal area, and 3.5 centimeters above the right eyebrow. Second one is puncture stab wound of size 2.5 into 1.2 centimeters on the anterior aspect of right chest on the sixth intercostal space, 1.5 cm from midline and 121 centimeter from the heel, almost triangular in shape. On dissection, two injuries. On dissection, I found the following internal injuries: subscalpal hematoma of size 5 cm into 4 cm, corresponding to injury number 1, scalp intact, membrane
intact, brain intact. Scalp intact, membrane intact, and brain intact. Punctured
stab wound on right side sternum, adjacent to and above the corresponding to injury number 2 with extra
into surrounding
tissues. The pericardium, the right
and right ventricle
of heart,
penetrating
stab wound size 1 cm into 0.75 cm. The stomach intact and contains 100 milli of mucoid fluid without any pungent odor.
With mucoid fluid without any pungent odor.
Opinion. The injuries mentioned above are antemotum in nature. The injury number could have been caused by moderately heavy and hard blunt force. The injury number 2 would have been caused by moderately heavy multi-edged pointed weapon. The cause of death is due to shock and hemorrhage resulting from the injury to the vital organ, that is heart. The time since death is about within 8 to 12 hours prior to the postmortem examination. Preserved blood stock gauge.
Preserved blood sock gauge. Scalp hair and nail
clippings handed over to the accompanying police to send to RFSL. Examination of the weapon of offense provided along with the body of weapon called locally as Gidisa, having a bamboo handle, having 7 nodes and 7 internodes of length 150 centimeters and maximum circumference 11.5 centimeters with metallic pointed blade of length 37.5 centimeter and maximum circumference 6.5 centimeter. The metallic blade has 4 surfaces and edges with gradually tapered to meet at the pointed tip. Rounded stents found near the pointed teeth and on the bamboo handle, which gave screening test for blood positive reaction. The total weight of the weapon is 14 grams. Opinion. The weapon containing blood stent and the above mentioned injuries can be caused by the provided weapon. The weapon is handed back to the police after examination. This is my report marked as Exhibit 2 and this is my signature marked as Exhibit 2/1. Cross-examination by defense. It is a fact that injury number 1 can be possible if a person come in contact and fall on stony object. It is a fact that by use of the weapon of offense, rectangular shape of injury as well as triangular injury can be possible. It depends upon the application of force and nature of tissues around the area of the body. It is not a fact that disease could have survived for a prolonged period, stay about 8 to 12 hours, having sustained such injury on his person if he would have been medically treated immediately. I did not find any bandage over the injuries on the dead body of the deceased at the time of my examination. It is a fact that I have mentioned in my report, Exhibit 2, that the weapon of offense contains human blood stain. It is not a fact that I have not properly followed the procedure while conducting postmortem examination over the dead body.
So, Mr. Tripathi,
Yes, sir.
what about the blows given by the accused persons, other accused persons who have been acquitted?
ଲାଠିରେ ଯୋଉ ବାଡି
ହଁ ଆପଣ ସମସ୍ତେ ମାରିଲେ ବୋଲି କହିଲେ ନା ଦିଟା ଇଞ୍ଜୁରି କେମିତି ହବ? ଇଏ ତ ଦିଟା
ଏ ଦୁଇଟା ତ ସ୍ପେଲ ଆଉଟ୍ କରାହେଇଛି
ଇଏ ତ ମାନେ ଦିଟା ଯାକ ଇଞ୍ଜୁରି ଯଦି ଆଟ୍ରିବ୍ୟୁଟ ହେଇଗଲା
for that reason perhaps the lower court could have acquitted.
No, that's all right, but another thing is that he has sustained also some injuries, this accused.
Yes.
So what explanation you have given? Of course, these are on the, one is on the vertex also, lacerated wound.
Yes.
On the scalp, and the other is, that is PW1, is the doctor.
Yes, sir.
Contusion on the right supraclavicular region. Simple injury, of course, the doctor has stated,
yes,
but so doesn't it presupposes that the statement of this eyewitness relating to the assault by the 3 accused persons is not believable?
Yes.
And
There is no,
it is not believable for which they have been acquitted.
yes.
It is that they have not given any blow at all to the deceased.
They have might given blow, but he has not sustained any injury.
କେମିତି
to
ହବ ଆପଣ
that blow.
how can it be? ଆପଣ ପୁରା ଲାଠିରେ ମାରିଲେ କଣ ଏମିତି ଆପଣ
ଏତେ ଜୋର ମାରି ନଥିବ କଣ ହେଇଥିବ? ନାଇଁ
no,
there must be some superficial injuries. Yes.
ଆପଣ ପୁରା
Swelling,
ଆପଣ
tenderness.
କହୁଛନ୍ତି ପୁରା assault କଲେ ଠେଙ୍ଗାରେ କଲେ ଆଉ ଆପଣଙ୍କର ଇଞ୍ଜୁରି ଆସିବନି ଜମା.
Examination has been done very promptly. Between 8 to 12 hours. Yes. Then
So
at least tenderness must be there. Redness, tenderness, nothing is there.
that means we are it is all right, they have been acquitted, but just what kind of witness he is in a case under section 302?
Yes.
If he is implicating some persons that they have also assaulted by this lathi and that part of the evidence is discarded, can it be said that the witness is absolutely reliable? Because the three categories of witnesses have been mentioned in the off-quoted decision of the Honorable Supreme Court.
That is PW9. PW15 is another eyewitness.
No, we are going.
We are going one.
Why are you jumping to that? We are categorizing three type of
Yes.
witnesses. They have stated absolutely reliable, no corroboration is necessary.
Yes.
Absolutely unreliable, throw it. If it is partly reliable and partly unreliable,
Yes.
then material
Further
corroboration is necessary.
Necessary.
We are just asking. We
Yes.
are not.
Yes.
So we, at least from this, we cannot place this witness under the category of absolutely reliable.
Yes.
That is what we are just bringing to your notice. So, all right. What the other eyewitness?
PW15, page 91.
Okay, please read it.
Yes.
I know the complainant, deceased Ananda Naik, and the accused persons of this case. The occurrence took place 4 years back. On the date of occurrence, at 7 a.m., I was cleaning my cycle on my house front veranda. At that time, the complainant and one Basanta shouted quarrel in front of the house of Nakula Naika of my village. Hence, Nakula Naika, father of Basanta, came there and caught hold of Pramod Naika. At that time, accused Chitra, Prabhasi, Bhaskara, and Kailasa assaulted Pramod. On our protest, they shouted with us and dispersed. Half an hour thereafter, in front of the house of Vishwanatha, again the accused person picked up quarrel with the complainant. At that time, Ananda Naika, the deceased father of Pramoda, came there, but accused Chitra dealt a blow on the head of the deceased Ananda by a Ghodisa and thereafter pierced the Ghodisa on his belly. As such, Ananda Naika died at the spot. I was examined by the police in this case. I also made statement before the JMFC Digapahandi regarding the case matter. Exhibit 26 is my said statement, wherein my signature is Exhibit 26/1. MO2 already marked is the said Ghodisa. Cross-examination. On the date of incident, at around 8 or 9 a.m., police examined in the case. The brother-in-law of deceased Ananda Naik is husband of my sister. Prior to the incident, my village panchayat election was held in which PW11 was a candidate for Sarpanch. Utshava Naika was contesting for the post of Sarpanch. On behalf of Janata Party,
on behalf of Janata Party,
the accused persons were propagating vote for Utshava Naika, including us. It is not a fact that we were supporting the contestant of Utshava Naika in the said election who stood on behalf of Congress Party. My village is around 20 km distance from Patapur, PS. On the information of the Gramarokhi and Sarpanch, police came to our village. I cannot say exactly as to who informed the police. On the date of incidents, police arrested Nakula Naika, whereas his son Basanta Naika fled away. It is not a fact that I did not state before the police the Basanta and Pramoda quarreled. It is not a fact that I did not state before the police and magistrate that Nakula Naika caught hold Pramoda Naika. It is not a fact that I did not state before the police that the accused persons assaulted Pramoda Naika in front of the house of Nakula Naika. I stated before the police that the deceased Ananda, having arrived at the spot, assaulted Chitrasena by a lathi held by him. I also stated so before the magistrate 15 days after the incident. Police called me to the PS and from there I went to Digapahandi to depose before the magistrate. At the PS, police told me to go to the court. Police told me to state before the magistrate what I stated before him about the incident. Police took me before the magistrate for my statement. Saura Naika and Balaram Naika also went with me to the court. After my statement before the magistrate, police left for the PS and I came back to my village. Pramoda did not call anyone to the spot at the relevant time. Almost all the street people gathered at the spot at the time of incident, but I cannot say their number. It is not a fact that Pramoda tried to snatch MO2 from Chitranayaka when he attempted to assault to the deceased, and while he was snatching the same pierced on the belly of the deceased, for which Pramoda fled away, leaving MO2 there. I cannot say how many knots are there in the MO2. There was no identification mark on MO2. It is not a fact that I, being relation of Ananda Naika, deposed falsehood supporting his case.
So, if the witness statement is perused, Mr. Tripathi,
Yes.
he has completely left the other three.
The Thenga bodies that and
That story is
No. So, your two eyewitnesses you are projecting before the court. One is implicating three persons apart from this.
Yes.
The other one is living. So, which version is to be accepted and why?
this person.
It is your witnesses.
Yes, Lord.
And you are to come forward with a truthful version. A man is facing charge under 302 along with others. It's all right, they have been acquitted.
Yes.
But these are the two witnesses watching the occurrence. They are the eyes and ears of the court, and they are coming, and one is stating that 4 persons participated. One gave 2 blows, that is the appellant. The others also assaulted by lathis, but the other is totally silent. He has not implicated anything against those persons.
No, at that time, accused Chitra, Prabhasi, Bhaskar, and Kailas assaulted Pramod once.
No, you deceased. You PW
Ah,
15.
PW 15.
On a
Hence, Nakula Naik, father of Basanta, came there, got hold of Pramod Naik. At that time, accused Chitra, Prabhasi, Bhaskar, and Kailas
Assaulted
Pramod is that man, that PW.
not the
No,
this
only
yes.
9.
This is it. This.
Yeah, that is
Ananda.
PW9. Yes.
This is with Ananda.
ତାପରେ ପରେ ଆସିଲା
ତାପରେ ସେ ପହଞ୍ଚିଲା. At that time, Ananda Naik, the deceased father of Pramod, came there. But accused Chitra dealt a blow on his head, on the head of deceased Ananda by a gun.
And then pierced her. So, not a single blow has been attributed against any other accused except the appellant.
Yes.
You are right that they have been acquitted, but just we want to see that effect of this version. You are coming forward with two eyewitnesses.
What PW 9, the informant, and PW 15, their statement about the this appellant to murder the deceased, that is corroborated. That is corroborated with the Ghadasi.
No. Again, you have not explained the injury on the accused. Accused has also examined on the very day.
Yes.
Accused को आपण ए जो चित्र सेन नायक.
Yes.
आपण immediately सेई दिन ही examine हेची.
Yes.
And
he has sustained 2 injuries.
Right.
Yes.
And they have taken a defense plea, that's all right. But no explanation coming from the side of the. So, এই जो ব্লোটা কথা কହୁଛନ୍ତି না ଆପଣ consistent ଅଛି?
Yes. With the Ghodisha. Yes.
So, you see how the PW9's evidence.
Yes.
प्रथमे आगे गोटे घड़ीसा ब्लो दिया गला डिसीज्ड को, that is page 75.
Yes.
Yes.
Accused Chitra means the appellant, assaulted my father means the deceased by means of a घड़ीसा on his head, as a result of which my father fell down on the ground. पड़ीगला पड़ीगला परे अन्य तीन जन मुदाला जो माने
ठेंगा
accused
लाठीरे बाड़ी।
ହେଇଥିଲେ, they assaulted by means of ठेंगा and लाठी.
Yes.
सेई पड़िथिबा अवस्थारे ताकू ठेंगारे माड़ा हला, तीन जन मारिचंती एवं while my father was lying on the ground, the accused Chitra stabbed the Gadisa on the abdomen, causing bleeding injury. So my father sustained severe bleeding injury on the head. Right?
Yes.
Now, এই ଆଖି ଆଗରେ ରଖିକିନି ଆଚ୍ଛା କେବଳ ସେତିକି ନୁହେଁ, ଆପଣଙ୍କର ଏଇ ଲୋକଟା ହଉଛି is the informant. You will find that in the ଯଦିଓ ଆକ୍ରମଣ ୱାର୍ଡ ୟୁଜ କରିଛି, FIR ଷ୍ଟୋରି ନୁହଁ ଯେ ସେମାନେ ଅନ୍ୟମାନେ ଲାଠିରେ ତାକୁ ମାରିଥିଲେ ବୋଲି, ହେଲା। FIR ରେ ଖାଲି କହୁଛି ଯେ ଚିତ୍ର ଧରିଥିବା ଘଡିସାରେ ମୋର ବାପାର ମୁଣ୍ଡ ଆଉ ଛାତିକୁ ଭୁଷି ଦେଲା, right? Then so far as PW15 is concerned, ଇଏ ତ ପ୍ରଥମରୁ ନଥିଲା, ଆସିକିନି ପହଞ୍ଚିଲା ପରେ କିଏ ଯେ deceased.
Yes.
At that time, Ananda Naik, the deceased father of the Pramod, came there, but accused Chitra dealt a blow on the head of the deceased by a Ghodisa and thereafter pierced on his belly. As such, Ananda died at the spot. So he has completely
He's keeping mum about the presence of those three. So he's speaking about the assault being made by the appellant, but he's completely silent with regard to three.
Presence is there.
No, whether presence
they are present there. And that I am reading that portion. At that time, accused Chitra, Prabhasi, Bhaskara and Koilasa assaulted Pramoda. On our protest, yes, informant. On our protest, they shouted with us and dispersed. Half hour thereafter, in front of the house of Vishwanath, again the accused persons, all the accused persons, picked up quarrel with the complainant.
এটা କିଏ କହିଲା?
এটা PW15.
ହଁ, ସେମାନେ କହିଲେ ଯେ ତାପରେ କଣ ହେଲା?
ତାପରେ କିନ୍ତୁ ମାରିଆ ପାଟଟା ଖାଲି ସେଟା
ପଡି କରୁଥିଲା PW9 ଙ୍କ ସାଙ୍ଗରେ।
Yes.
ସେତିକି ବେଳେ ଆସି ଡିସିଜ୍ଡ ପହଞ୍ଚିଲା, ସେଇଟା ହଉଛି ମୋଷ୍ଟ ଇମ୍ପୋର୍ଟାଣ୍ଟ।
Yes.
PW15
The deceased father Pramod came there, but the accused Chitra dealt a blow.
ଯେମିତି ଆସିଛି, ତାପରେ ତାକୁ କେବଳ
ଚିତ୍ର ମାରିଛି। Yes.
ଜଣେ ହିଁ assault କରିଛି।
Yes.
So what we say that you are just making a submission.
Yes.
That ଯେହେତୁ ସେ ତିନିଟା ଆକ୍ୟୁଟାଲ ହେଇଗଲେ, ତେଣୁ ଏ ଏଭିଡେନ୍ସ ତାକୁ ଛାଡି ଦିଆଯାଉ, ବାକି ତ କନସିଷ୍ଟେଣ୍ଟ ରହିଛି, ତେଣୁ ତା ବେସିସ ରେ ଇଏ କଲେ। That is only your submission.
Yes.
But can you say that these two evidence of these two witnesses relating to the assault on the deceased, they can stand together?
Regarding the FIR Miller, that is consistent with the PW15 version.
ଯଦି FIR ରେ ଗୋଟେ ସାକ୍ଷୀ କହୁନି, ଯଦି ସେ ତିନିଟା ଆକ୍ୟୁଜ ତାକୁ ବାଡିରେ ମାରିଛନ୍ତି ବୋଲି ତା
FIR କହୁନି।
No. He is introducing for the first time in court
by the informant.
Informant.
Yes.
So how it can be said that the witness is a truthful witness? And again, if he comes under that category which you say, then the only corroboration is to come from which witness? The other eyewitness. The other eyewitness, is it not contradicting him regarding participation?
Participation to other three accused. Yes.
ଆପଣ ଯୋଉ corroboration ଯୋଉ source ରୁ ଆଣିବେ, ସେଇଟା ତ ହଉଛି PW15 ନା?
Yes.
ସେ PW15 ତାକୁ contradict କରୁଛି, ତେଣୁ corroborate କଣ କରୁଛି? ତାକୁ contradict କରୁଛି ନା, rather
he omitted the name of this
person.
So this omission seems to be very vital.
Vital
So,
omission.
vital omission is a contradiction.
ଏଇଟା ହଁ ଛୋଟ ଛୋଟିଆ ତିନି ଜଣ ଆକ୍ୟୁଜ କୁ ଯୋଉଟା ଇଏ କରୁଛି ନଟ୍ ଓନ୍ଲି PW5 କୁ ଆପଣ ସେ କାଟାଗୋରୀରେ ଆଣିପାରିବେନି ଯୋଉ PW9
Nine group.
absolutely reliable ଆଣିପାରିବେ ନାହିଁ ଆପଣଙ୍କର କେସ୍ ହଉଛି ଇଏ ଗୋଟେ କାଟାଗୋରୀରେ ଆସିବ ପାର୍ଟଲି ରିଲାଏବୁଲ ଆଉ ପାର୍ଟଲି ଅନରିଲାଏବୁଲ ହେଲା ଯଦି ତା ପାଇଁ ଲ ହଉଛି ଯେ ଦେୟାର ମଷ୍ଟ ବି corroboration to the corroboration ଆପଣ ଯୋଉ source ରୁ ଆଣିବେ ସେ corroborate କରୁଛି କି ତାକୁ ଆପଣ କହିବେ partly corroborate କରୁଛି ଆରେ corroboration ପୁଣି ଯୋଉ source ରୁ ଆସିବ ସେଇଟା ତ ପୁଣି complete corroboration ହବା ଦରକାର ତାହେଲେ ସବୁ ୟାଦରୁ ଫାଳେ ସେଠୁ ଫାଳେ ତାପରେ ସେ ଏଥିରୁ ଏମିତି ଯୋଉଗୁଡାକ ଆପଣଙ୍କୁ ସୁହାଇବ ମାନେ prosecution କୁ ସୁହାଇବ ଆମେ ସେଇଗୁଡାକ ନେଇକିନି ତାକୁ କନଭିକ୍ସନ କରିବୁ ଆଉ ଦି ତିନିଟା ଛାଡି ଦେଇଛନ୍ତି ଏଇଠି ଏଇଆ କରିବୁ ନା ଆଉ ତାର କିଛି ୱେ ଆଉଟ୍ ଅଛି
Any other material other than that? That part we'll see.
and apart from that that injury not explained ଆଉ କଣ material ଅଛି ଆଦେରେ ଏ ଦିଟା ତ ପଢିଲେ ଏବଂ ପୋଷ୍ଟମର୍ଟମ ପଢିଲେ ଆଉ ଏଇ ଯୋଉ
ଆଉ କି PW10
କିଏ
one postal ଅଛି postal ଯେତିକି କହିଛି ସେତିକି ଅଛି
କଣ ପଢୁନାହାନ୍ତି
I know all the accused person, namely accused Chittaranak, Bhaskar Naik and so and so. They are all of my co-villagers. The occurrence took place 2 years back at about 7 a.m. morning near the coconut tree on our village dando in front of the house of Sumo Naik and Vishnu Naik. At the relevant time, I had been to the village tank for answering call of nature, and when I was returning to my house, I found that the accused person were quarreling with Pramod Naik. At that time, Anand Naik was coming
Pramod Naik is PW9
yes. At that time, Anand Naik was coming towards his son Pramod Naik.
Right.
I found Anand Naik assaulted accused Chitra Naik by means of Jogali body.
Just see that
On his
Anand
head.
Naik means the deceased.
Yeah, deceased assaulted
the
yes.
appellant.
Yes.
Yes.
I immediately thereafter accused Chitra Naik assaulted Anand Naik by means of a ghodisa which was armed by him on his hand. Again, the accused Chitra Naik stabbed the said ghodisa on the chest of Anand Naik. Thereafter, Anand Naik fell down and died on the spot near the coconut tree. Thereafter, accused person left the spot by holding their instruments.
Just take pause for a moment.
Yes.
This man, so if the evidence of your witness, that is PW10,
yes.
is taken into account, then the first assault
was made by the deceased.
Right?
Yes.
আচ্ছা এই ଯୋଉ ଜିନିଷଟା ଯଦି ହେଲା ଆପଣ ଆକୁ କମ୍ପେୟାର କଲେ PW9 ଆଉ 15 ସାଙ୍ଗରେ
ସେମାନେ କହୁନାହାନ୍ତି
ତାହେଲେ କେମିତି ଆପଣ କୋଉଟା ସତ ପୁଣି ଆପଣଙ୍କ କେସରେ ଏ ପାର୍ଟଟା ସେ ଯଦି ସେଠି ନାହିଁ ଟୋଟାଲ ତାହେଲେ ହାଉ ରିଲାଏନ୍ସ କ୍ୟାନ୍ ବି ପ୍ଲେସ୍ଡ ସେ ତାମାନେ ସେଇ ଯୋଉ ଦି ଜଣ ସାକ୍ଷୀ କହୁଛନ୍ତି ଯାହାକୁ ଆପଣ rely କରୁଛନ୍ତି they are also leaving a part of the occurrence deliberately.
Yes.
They are withholding something from the court regarding the assault by the deceased to the appellant. That the assault start from that point of time according to PW10. So ବର୍ତ୍ତମାନ ଆମ ପାଖରେ ତିନିଟା ଷ୍ଟୋରି ଆସି ପହଞ୍ଚିଲା ଆପଣଙ୍କର ଯୋଉ ତିନିଟା ସାକ୍ଷୀର ଏଭିଡେନ୍ସ ପ୍ଲେସ୍ ହେଲା ଗୋଟେ ସାକ୍ଷୀ PW10 କହିଲା assault ଆଗେ ଷ୍ଟାର୍ଟ କଲା deceased ଯୋଉଟା ନା PW9 କହୁଛି ନା PW15 PW9 କହୁଛି ଏ appellant ଛଡା ଆଉ ତିନି ଜଣ assault କରିଛନ୍ତି which is not the case of either PW10 or PW15. Acha, this witness has been declared hostile.
Hostile.
Also. Okay, just read that portion.
Confront जोटा करा
Confront
leading
करा,
question.
leading,
Yes. Yes. It is a fact that I have been examined by the police in this case. It is a fact that I have stated before the police that while deceased Anand Naik was going to save his son Pramod from the clutches of the accused person, accused Chitra Naik assaulted him on his head by means of a Ghodisa first, and thereafter deceased Anand Naik assaulted accused Chitra Naik by means of Jogali.
ସେଠି ବି କହିଥିଲା assault part କହିଥିଲା deceased ମାରଲା ବୋଲି କହିଥିଲା କିନ୍ତୁ ପ୍ରଥମେ କହିଥିଲା
deceased ମାରିଛି first ବୋଲି ବର୍ତ୍ତମାନ କହୁଛି ଚିତ୍ର ନାୟକ assaulted
Second time ମାରିବାଟା cannot be believed because by then he is almost in a moribund condition. Stabbed injury by Ghodisa is always there. Then the first statement that deceased gave the blow, showing that he is the aggressor.
तार court statement आउ previous statement दीटा जगह से कहिची deceased मारिला
first blow.
नहीं first में एठी कहिची second किंतु deceased मारिया कथा कहिची. What is been pointed out the first one which is stated in the chief portion prior to being declared hostile, that appears to be more probable कारण से मारला परे आउ ये जो मारला परे पुनी आउ opportunity पाइबो that जो type of blow ହେଇची, so that is
अच्छा 161 रे how they have stated whether consistencies have been made or like this only.
नहीं once you are confront ହେଇଛି ନା ପଚରା ହେଇଛି हां सब ପାଇଛି ତାକୁ.
I don't know.
ये not a fact not with the IO
PW16
हां से contradiction part कोडा देखिले बड़ा पचरा जन देखने राइट पेज नंबर से contradiction part को पढ़े आसन जो 9 नंबर साक्षी रो contradiction अछि पेज 104 रे paragraph number 14.
Yes, it is a fact that the informant
just 104 paragraph 14.
It is a fact that the informant Pramod Naik PW9 has not stated before me that on the date of occurrence the accused person had come near his house. It is a fact that he had not stated to me that while his father was lying on the ground, accused Chitra stabbed Gidisha on his abdomen and the other 3 accused persons assaulted him by means of thenga.
देखो के material commission रहुची तार ए जो abdomen portion रे
stabbing
stab wound टा एवं तापरे अन्य 3 जन एगुडा किछि कहनी एडा first time कहूची.
The affair has been scribed by Utshava Naik PW11. It is not a fact that as per my instruction he scribed the affair. It is a fact that I have not given any endorsement in the affair, that the contents of affair was read over and explained to the informant who admitted the same to be correct as there is no scope for the same.
Now you come to that other witness, जो PW 15. तार food पचराइची से एग्जामिन करथला ना और की करथले.
Yes,
हां अच्छे paragraph number 16 में
there was no previous enmity between the deceased and the accused person. I have examined Pandava Naik.
पांडव नायक के PW 15
नहीं
पांडव जी सोमनाथ नायक
Pandava Naik. I have examined Pandava Naik It is a fact that, as per his statement, the informant had gone to Tipu Bandha on 21/8/2003 at about 7:30 p.m. for purchasing of liquor. It is not a fact that during the alternation between the informant and the accused person, the deceased suddenly arrived there and assaulted Chitra by means of lathi, and when Chitra wanted to assault the deceased, at the time informant snatched away the ghidisa, which came out of the hand of Chitra and pierced in the body of the deceased. At that time of my arrival, one towel was tied at the wound to check bleeding, but there was no first aid given. I have not seized the wearing apparels of the informant. It is a fact that I have not specifically requested the RFSL to trace out any fingerprints if appearing in MO2. It is not a fact that there was no stain of blood MO2 at the time of seizure. It is not a fact that I have suppressed most of the material of the case and that my investigation is pre-punctured.
Pre-punctured. Perfunctory.
ଏ ଯୋଉ ଆର 161 ଟା ଟିକେ ଦେଖିବା ପ୍ରମୋଦ ନାୟକ PW9 ଡେରି ପଡାଲା
Somnath Naik is a witness.
Somnath Naik is PW15?
Of 15.
Yes.
In his 164, he has stated. No, again, with regard to Pramod only. ସେଇ ସମୟରେ
ଆନନ୍ଦ
ଚିତ୍ର ଘଡେଇସା ଦ୍ୱାରା ଆନନ୍ଦର ମୁଣ୍ଡକୁ ବାଡିଲା, ଆନନ୍ଦ ମଧ୍ୟ ଠେଙ୍ଗା ଦ୍ୱାରା ଚିତ୍ର ମୁଣ୍ଡକୁ ବାଡେଇ ଦେଲା।
ସେଇଟା
ତାପରେ ଚିତ୍ର କିନ୍ତୁ
ଯୋଉଟା କି ସିଏ ବି ସପ୍ରେସ୍ କରିଛି ସେ ଯୋଉ
ସେ ଇମ୍ପ୍ଲିକେଟ କରୁଛି, ଇଏ ତାକୁ ଓମିସନ କରୁଛି।
ନାଇଁ PW9 ବି ସେ ବିଷୟରେ କହୁନି ନା। এইটা ଟିକେ ଦେଲେ ଯୋଉ କେସ୍ ଡାଏରୀଟା ସେ ଷ୍ଟେଟମେଣ୍ଟଟା କାଢି ଦିଅନ୍ତୁ PW9 ର ପ୍ରମୋଦ ନାୟକ ତାର ତ 164 ହେଇନି। ପ୍ରମୋଦ ନାୟକ ତ 164 ହେଇନି।
Yes. ହେଇଛି ପ୍ରମୋଦ।
ପ୍ରମୋଦ
PW9 ଇନଫର୍ମର। ହଁ
ବଳରାମ ନାୟକ ରହିଛି ସେ ହଷ୍ଟାଇଲ।
What type of weapon that is?
ଘଡି ସାର୍
ସେଟା
What is
ଉପରଟା ଦେଇଛି ଡକ୍ଟର କହୁଛନ୍ତି
ତିନିଟା ଭଳିଆ ବୋଧେ ମତେ ଲାଗୁଛି।
ବ୍ଲେଡ୍ ଅଛି ସାମ୍ନାଟା ଯୋଉଟା
ସେ ଗୋଟେ ନାଇଁ ସିଏ କହୁଛି ଓଜନ ଟା ପୁରା ଜମା ସେଇଟା
ଓହୋ
ଜଣା ପଡୁନି।
ଫାର୍ସା ଭଳିଆ ଫାର୍ସା ଭଳିଆ
ନାଇଁ ନାଇଁ ଫାର୍ସା ବୋଥ୍ ସାଇଡ୍ସ ରେ ଥିବ।
ହଁ।
ବାମ୍ବୁ ହ୍ୟାଣ୍ଡେଲ ଲାଗିଛି 7ଟା ନୋଟ୍ସ ଆଉ 7ଟା ଇଣ୍ଟର ନୋଟ୍ସ ରହୁଛି। ଲେନ୍ଥ ହଉଛି ଏତିକି, ମ୍ୟାକ୍ସିମମ୍ ହଉଛି ମେଟାଲିକ ପଏଣ୍ଟେଡ ବ୍ଲେଡ ର
ଅଛି
ଲାଗୁଛି।
ତାମାନେ ହ୍ୟାଣ୍ଡେଲ ଟା ହଉଛି
Gum
wooden
stick,
having nodes
Yes,
ହଁ
ଗଣ୍ଠି ଗୁଡାକ ରହିଛି।
ଗଣ୍ଠି ଗୁଡା ରହିକିନି ଉପରଟାରେ
ଅଛି blade
ବ୍ଲେଡ
ଟା।
ପୋର୍ସନ ରହୁଛି। ଗାତ କରି। ହଁ ସେ କହୁଛି ନା metallic blade has 4 surfaces with edges with gradually tapered to meet the pointed ones. Total weight is only 14 grams. पाइला देखिए
10 ग्राम
Yes, that decision at 76 Supreme Court that off-courted decision हुए, जो suppression करे,
Yes.
You are suppressing the genesis of the crime. If you are suppressing that how the accused sustained the injuries, if it is superficial in nature is different, but if he has sustained same time रे मध्य ହେଇଛି ଏବଂ then it is duty bound on the part of the prosecution. ତେଣୁ ଗୋଟେ witness ଆପଣଙ୍କର କହିଛି, it's not that in court he is telling it, that is in the statement in the 164 also, that is his previous statement. Of course the sequence is something different, କିନ୍ତୁ କହିଛି ସେଇ part ଟାକୁ ଆପଣଙ୍କର ଆଉ ଦିଟା ଯୋଉ ଆଇ ୱିଟନେସ୍ ସେଟାକୁ
omit କରୁଛନ୍ତି।
ହଁ ଏବଂ ଓମିଟ୍ କରୁଛନ୍ତି ତ କେବଳ ସେଠିକି ଓମିଟ୍ କରୁନାହାନ୍ତି, 3 ଜଣକୁ ଆକ୍ୟୁଜ୍ଡ କୁ ଆଣି ତା ଦେହରେ ପୁରଉଛନ୍ତି ଗୋଟେ ୱିଟନେସ୍ ଆଟଲିଷ୍ଟ
PW9 ପୁରେଇଛି।
So are they reliable to base conviction?
Yes, ma'am.
Question
Are
is
they
put to you that in a case under section 302, if this is the type of evidence coming from 3 witnesses, ଆପଣଙ୍କର star witness ହେଲେ 3ଟା ନା,
3ଟା
9, 10, 15.
Yes. But
ହେଲା?
10 turned hostile.
Hostile witness
The,
cannot
the,
be.
the part of the chief examination.
Yes.
Yes.
Hostile witness ର principle ଟା ନୁହେଁ ଯେ ତାକୁ ଖାଲି ଗୋଟେ
Totally, yes.
part ରେ ହେଲେ total ତାକୁ ଇଏ କରିଦବ। ଯୋଉ part ଟାରେ ଆପଣଙ୍କର ଇଏ ହେଇଛି ଆପଣ ତାକୁ ଇଏ କରିପାରିବେ ଯୋଉ part ଟା defense it's not that he has not stated anything.
Yes, yes.
He has stated many things. ଯୋଉ part ଟାକୁ ଆପଣ ଆଣିଛନ୍ତି ତା ଦେହରେ sequence ଟା ଅଲଗା ହେଇଛି।
ହଁ।
Right?
Yes.
ସେ ଯୋଉ ପ୍ରଥମେ କହୁଛି deceased ମାରିଲା
assault କରୁଛି।
ହଁ ସେଇଟା ଆପଣ ଆଣିଛନ୍ତି ଯେ ନାଇଁ ଆଗେ accused ଗୋଟେ blow ମାରିଲା ପରେ deceased ମାରିଲା ତେଣୁ deceased blow ଟା ରହିଛି but କୋଉ stage ରେ ରହିଛି that is the difference. So ସେଥିପାଇଁ ଆପଣ total କହିପାରିବେନି ଯେ hostile ଟା ତାକୁ ଛାଡି ଦିଆଯାଉ ହେଲା ତାପରେ ଆପଣ ଯେହେତୁ ତିନିଟା ପ୍ରୋଜେକ୍ଟ କରିଛନ୍ତି ତିନିଟାଙ୍କର ଏଭିଡେନ୍ସ କୁ ଆପଣ ଛିଡା କରେଇ ଦିଅନ୍ତୁ ଗୋଟେ ଗୋଟେ କରି ଗୋଟେ ଆପଣଙ୍କର 4 ଜଣକୁ ଇମ୍ପ୍ଲିକେଟ କରୁଛି ଚାରି ଜଣ ଯାକ ମାରିଛନ୍ତି ହେଲା ଆକ୍ୟୁଜ ଦିଟା ମାରିଛି ଆଉ ଏଇ ଯୋଉ ଆକ୍ୟୁଲାଣ୍ଟ ଆଉ ତିନିଟା ମଧ୍ୟ ମାରିଛନ୍ତି ଇଏରେ ତା ପାଇଁ ଇଞ୍ଜୁରି ହିଁ ନାହିଁ ନେକ୍ସଟ ୱିଟନେସ ଆସିଲା ଯିଏ କି ଟୋଟାଲ କହୁଛି ଯେ ପ୍ରଥମେ ଆକ୍ୟୁଜ ଷ୍ଟାର୍ଟ କଲା assault ଡିସିଜ ଏବଂ କରେସ୍ପଣ୍ଡିଂ ଇଞ୍ଜୁରି ମଧ୍ୟ ରହିଛି ଏବଂ ତାକୁ ହୋଷ୍ଟାଇଲ ଯଦିଓ କରିଛନ୍ତି ଏଗେନ୍ ସେମ୍ ଥିଙ୍ଗ ହାଜ କମ୍ ବଟ୍ ଦ୍ୟାଟ୍ ଇଜ ଏନ୍ ଡିଫରେଣ୍ଟ ଯୋଉ ପାର୍ଟ ଟାକୁ ଆପଣଙ୍କର ଆର ଦିଟା ସାକ୍ଷୀ ଛାଡି ଦଉଛନ୍ତି 9 ଆଉ 15 ହେଲା ଯେ deceased has assaulted the appellant first that is not stated by either 9 or by 15 next ପଳେଇ ଆସନ୍ତୁ 15 ର ଏଭିଡେନ୍ସ କୁ ଯଦି ଆସିବେ ଆପଣ ନାଇଟ୍ ଟ୍ୟାଲି ସେ ତିନି ଜଣକୁ ଛାଡିନି କେବଳ ଏ ଯୋଉ ଡିସିଜ୍ଡ ମାରିଲା ମଧ୍ୟ ଛାଡିଛି ତେଣୁ ତିନିଟା ଭେରାଇଟିର ଏଭିଡେନ୍ସ ଆମ ସାମ୍ନାରେ ଆସୁଛି ତେଣୁ now the question duty of the court is to separate the grain from the chaff ତେଣୁ ଏଠି କୋଉଟା chaff କୋଉଟା grain how far you are to satisfy that how we leave what portion merely because 3 persons have been acquitted can it be said in such a situation that the chaff has been separated and only on the grain portion the conviction has been sustained.
But the assault part on the deceased, the 3 person are corroborating each other.
No, assault ଆଉ ବାକି ସେଇ
ଆଉ ଅନ୍ୟ କାହାର ନାହିଁ
ଆପଣ say again that then the question is that yes that part is consistent but can you leave everything else merely because that part is consistent which is the other part which goes in his favor but which is inconsistent which creates doubt about the truthfulness of the prosecution which goes to show that the prosecution is suppressing a part of the occurrence that means on the assault part at least ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ completely ଆମେ overlook କରିପାରିବୁ କି now ଯଦି ଆପଣ କହୁଛନ୍ତି ସେଇ ପାର୍ଟଟା consistent ଅଛି ତାକୁ and you see that statement made by the that eyewitness is a ଆପଣ contradiction ଦେଖିଲେ ନା PW9 ର ଯୋଉ ପଡିଗଲା ପରେ stab wound that is not stated
not stated in the FIR. ପଡିଗଲା ପରେ ନା after the assault he fell down that is on FIR.
we are keeping this matter tomorrow. You find out the decision. We have a discussion on all these things that 3 type of witnesses part of the evidence has been disbelieved suppression of that injury on that all those things
suppression of injury omission of name of the culprits
and in a case under section 302 there is a decision that in a case under section 302 if somebody implicates accused persons in that crime, that means in ki I'm PW9.
Yes.
That witness cannot be partly reliable be ହେଇପାରିବନି ତାକୁ total
Discard.
you are to discard, because in a case under section 302, if he has implicating 3 persons to have assaulted the deceased, which he has not stated, which there is no injury, so he cannot be said to be a partly reliable and partly. His evidence is to be totally discarded. Say light re madhya decisions are there. So find out all those decisions. So Mr. Tripathi,
Yes, sir.
will take up this matter
Tomorrow.
Custody from 19 December 2020. Kindly taken up, my lord.
Serially ne bhi ja jetale padibo. Yes.
My lord,
Main list item number 55. In that case, why the matter reached, but due to the absence of the Vigilance Council, it was taken up. So yesterday, I personally requested Mr. Rijvi, he has sent my learned friend. Item 50 may be taken up today because before, after 3, since last summer vacation, I'm trying after that case.
You see that. She is there, so take up.
my lord, item number 320, it is a juvenile bail matter, my lord. It's for 1 month, it's not reaching, my lord.
It has already been called for
320.
CD, etc.
No, my lord. It has not reached
300.
20. Item number 320, my lord.
There are some defects. What are the defects?
Charge sheet and social investigation report I have filed, my lord.
So you are claiming yourself to be a minor, but you have signed wakalatnama. How can it be entertained? You have to file a fresh wakalatnama. You have mentioned your petitioner to be aged about 17 years.
My lord.
But all the same, that 17 years boy has signed the wakalatnama.
Father has given the memo also.
Your father has to sign the wakalatnama, not the minor child. So file the wakalatnama, proper wakalatnama.
My lord.
What is the size?
My lord, my lord.
320. The learning counsel for the
My lord,
petitioner seeks permission to remove the defects as pointed out by the stamp reporter within a week. Let the learning counsel for the state obtain the case diary as well as the social investigation report.
my lord, criminal appeal number 1.
Permitted to withdraw, my lord. Weekly list item 291 permitted to withdraw.
Okay, learned counsel for the petitioner has filed a memo for withdrawal of the bail application disposed of as withdrawn. Item no
Criminal appeal number 1255, my lord. Fresh admission.
Pardon to mention, my lord. My lord, this is a tie-up matter, my lord. My lord, earlier, my lords have rejected bail. His language English more than 5 years, my lord.
This is item 210. That expeditious trial within 6 months. Which item? Item 210. Yes, what do you want?
Expedient trial within 6 months, 17 but now repeatedly matter as I have mentioned what matter.
No, there was earlier a direction to dispose of that to conclude the trial within 6 months.
I have got the certified copy,
Ah.
but out of 70, 2 witnesses have observed.
So let me call for the status report. What is the order dated you have got?
Your Lordship, last order dated 17/11/2023.
That indicates only 2 witnesses have been
Yes, Your
examined.
Lordship. That's seizure witness.
What is the earlier BLAPL number?
BLAPL number 5692/2022.
And you are in custody since? And you are a man from state of UP.
Your Lordship, that the second accused Asim Malik.
Huh?
I have noticed that second petitioner Asim Malik. That the second accused.
Second, okay. So second of what?
On similar putting, both have.
Wait. No, you are a man from Malkangiri.
Yes. Petitioner is the local person. Written question 26/9/2021.
The other case was of this man, the other co-accused bail application. जोटा देखौथिले 5 केते
I'm not moving for the Mukesh Kumar. He is not interested, so I'm moving for only Asim Malik.
So that was a direction so far as that petition is concerned. But for you, there is no such. This is your first bail application.
Yes, sir.
All right. Let me call for the status report. We'll see.
You also, this is the certified copy of that.
Pass on.
Pardon to mention, my lord, 312, my.
देखिए.
Last date is 12/12 ଅଛି. Next date. Now.
याद तो किसी जଣା पड़ुनी आपनकर PW2 टा से 10th August 2023 रे ହେଇଛି तापरे कोन ହେଇଛି ऑर्डर ଆଉ କି ଜଣା ପଡୁନି.
You also second witness that kindly glance over the second witness. That
6-7 foot of
the second page. On 17/11/2023, no CSW seizure witness is present. Issue summons to the CSW.
Are the learned counsel for the petitioner, learned counsel for the state. This is item number 210, the second item. The BLAPL number 674 of 2020. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since Kebet Roychandi 24/9/2021.
21.
When the co-accused, namely
Mukesh Kumar.
Mukesh Kumar approached this court for bail in BLAPL number 59692 5692 of 2022 as per order dated 17/1/2023. While rejecting the application for bail, the London trial court was directed to expedite the framing of the charge and to take steps for concluding the trial within a period of 6 months from the date of framing of the charge. And the said co-accused was granted liberty to renew the prayer for bail after if the trial is not concluded within the said period. So that was the observation that 6 months it is to be concluded from the date of framing of the charge. Okay. Now, when the charge was framed, Last thing I have no statement, but that will the learned counsel for the petitioner produce the certified copy of the deposition of two witnesses, so also the order sheet, and submitted that only two witnesses have been examined, but nothing is mentioned in these documents to show that when the charge was framed, the learned report be called for from the learned trial court regarding date of framing charge as well as about the status of the case. File be placed before registered judicial who will communicate the order. So these are taken on record. Yes.
Lordship, item number 317. This is a juvenile justice bill, Lordship. Lordship, petitioner custody since 7/1/2021, Lordship. 317, Lordship.
This is coming for the first time.
No, Lordship, this is regularly listed but not listed, Lordship. Lordship, custody since 2021, 7/1/2021. Already.
So you have got the case diary, Mr.
Lordship, case.
Bring the case diary because there is no order to that effect. So case diary and social investigation report. So this is item number
317, Lordship.
317, 317.
317, Lordship.
All right. The learned counsel for the state. There was there was earlier order that to produce the CD and social investigation report.
Lordship, already.
That bring that file. Yes, next.
My lord, criminal appeal number. I may pardon, my lord. Criminal appeal number 71 of 2016. This matter was listed before Lordship on 1/8/2022. On that day, your Lordship, it's a short matter your Lordship had and directed both of us, my lord, me and to the State Council, Vigilance Council, to submit the written note only. Thereafter, by order dated 16/11/2023, my lord, I have mentioned this matter before your Lordship. Your Lordship directed the matter to be listed today. It's a copy again. Your Lordship, kindly see your Lordship's order dated 16/11/2023. Lordship.
जे आपण रिटन नोट ଦେଇଦେଲେ ଯେ ଶୁଣାଣି पर आरंभ ହେଇନି तो ଶୁଣାଣି କରିବା ପାଇଁ ସମୟ ଦରକାର ନା ଆଉ ଖାଲି
ଶୁଣାଣି କରିସାରିଥିଲେ ଖାଲି
କୋଉଠି ଶୁଣାଣି କରିବେ ସିଏ ମୂଳରୁ ଆରମ୍ଭ କରିନଥିଲେ ଆପଣ ବି ଆରମ୍ଭ କରିନଥିଲେ ଆଉ ଟିକେ ଶୁଣିଲେ ସିନା ରିଟନ ନୋଟ ଦେବା ଖାଲି ରିଟନ ନୋଟ ଦେଇଦେଲେ ତ ମୁଁ ଘରେ ବସି ସବୁ
ଆଜି ଫିକ୍ସ ହେଇଥିଲା ସେଇଥିପାଇଁ
ହେଲା ଯେ ଏଇ ଆଜି ଯୋଉ ଦେଖୁଛନ୍ତି ହାଟ ହେଲାଣି ଆଉ ସେଠି କଣ ନିଆଯିବ
ଗୋଟେ ଡେଟ୍ ରଖନ୍ତୁ ସର୍ଟ ଡେଟ୍ ଫିକ୍ସ ଗୋଟେ ସର୍ଟ ଡେଟ୍ ଫିକ୍ସ ହଉଛି
Item 237
lordship fixed
coming week ରେ ଆସିବ
coming week
237 your lordship 237 that is anticipatory bail application your lordship that matter lordship granted co-accused bail a similar putting 237 your lordship 237 I have annexed the co-accused order your lordship granted annex 2 page 13 similar putting रे गणेश पूजा गंडगोल
आणନ୍ତୁ ସେ ଦେଖିବେ ନା ଆଉ ତାଙ୍କର କେସ୍ ଡାଇରୀ ରେ ଦେଖିବେ ଆପଣ सेम फुटिंग की नहीं केम जानिबे
तो एफआईआर अछि आगे समस्त ना लॉर्डशिप ऑब्जर्व करचंती जो ऑर्डर रे
मैं भी पार्डन में आइटम 330 ऐसे विजिलेंस केस में लड़
हां 330 मिस्टर राव कौन हला
that case is posted to second for framing of charges. I have come against an order refusing to discharge me. If your lordship will take it up tomorrow, I can inform the Vigilance Council to remain present.
Vigilance Council, that madam is here for Paleli. Is it quarterable? So, who is to argue this matter, madam? Item number 330 is a discharge petition against Ashchanti.
Revision matter.
Yes, revision matter.
Mr. Sangram Das will argue the matter.
Acha, tell him to remain present because Mr. Rao is mentioning this matter. Okay.
Today.
Pardon, my lord.
209.
Pardon, my lord.
209. The main accused has been released since 2020, and the petitioner is in custody.
We'll see when the matter reaches
2019.
Matter reaches, you will verify whether both of you stand on the same footing or not.
Pardon, my lord. Tied up matter, one tied up matter, my lord, fresh matter,
June.
and one appeal, my lord.
72, my lord. Principal accused already reasoned by principal court.
No, you wait. They will verify the record.
Item 72, my lord. Item 198, 10 years first. Already 6 hours already covered. Last time died.
198 बेल मैटर ना सी पढ़िले सी खाता कागज पत्र काढ़िबे देखिबे आ अबिया केमती नै हेला जे सब देखिबे ना कागज पत्र ये
111 my lord 111 so more than 5 years in custody my lord NDPS matter and co-accused so those hardcore accused has already been released by court my lord this
111 la BLFL
my lord
all right when the matter reaches we'll see that yes
weekly list item 241 permitted to withdraw lordship 241 weekly list item 241
241 withdrawal memo filed acha withdrawn for the ABLFL 13644 yes
Pardon to mention, my lord.
May be taken up tomorrow 209
Little ASIO
item 143 my lord there my lord has targeted the case my lord and in the meantime one co-accused has also been granted bail by the apex court my lord always pray a status report be called for
143 or status report
okay
all right the learned counsel for the petitioner submits that the petitioner is in judicial custody since kebe
more than 1.5 years my lord
more than 1.5 years and what is the position of the trial
not my lord to my instruction only charge has been framed no
and he has instruction that no witness has yet been examined let a status report be called for
item 300 out of 252 my lord item 252 there my lord is also targeted and my lord also directed me to give copy of the all deposition I have given copy of all deposition the co-accused has also been granted by this honorable court my lord
you want status report
no their status report my lord
then it's all right wait
item 334 item 334 one of the co-accused to person has released by honorable justice D Das
what do you want
let the letter be listed before
334
weekly list
yes who accused has been
released by the honorable justice D Das the order is supplied
that is in
vision in form of
153 of 23 देखिए the learned item এটা হচ্ছে item number 334 the learned counsel for the petitioner submitted that the co-accused Manoj Bhukta approached this court for bail in CRL REV number 153 of 2023 and his bail application was allowed by the order dated 22/6/2023 by Honorable Justice D. Das. He produces the copy of the order which is taken on record. In view of such submission, put up this matter before appropriate bench with CRL REV number 153 of 2023 with the permission of the Honorable Acting Chief Justice.
Item 58
284 my lord 284 here my lord allegation of 3990402 your lordship last occasion called for the antecedent because co-accused person similar footing has released on bail and the lordship subject to verification
no let's see
item 58 my lord anticipatory bail my lord
58
my lord it's an anticipatory bail co-accused ଯାଇଛନ୍ତି ସବୁ my lord kindly be taken up
ଦେଖନ୍ତୁ co-accused same footing ki nahi 58
item 22 weekly list permitted to withdraw my lord
22, it is BLAPL number 11438
Yes, madam.
of 2023. You are filing a memo.
Yes, ma'am.
The Learned Counsel for the petitioner files a memo, withdrawal of the bail application, disposed of as withdrawn. Yes, Mr. Mishra.
263.
Yeah.
I have received a copy of the letter which has been sent to the Honorable Court from the jail.
263.
Item 263. A letter has been received from the jail.
Yes.
Seeking permission to engage me.
Just a
But
minute. Let me see that. Item 263, 194. Letter flag B. So and so.
Probably could not get the no objection certificate because of his handicapness. He is in custody.
No, it's all right. Flag B रे तो किसी नहीं तो कौन लगे letter received from से letter टा होची आंकर additional session judge come
आगुटे letter टा अछि सेठे
263
गोटे
होची
जेल रो गोटे letter टा आइछि
BLAPL 4194 of 23 तो
yes गोटे जेल रो गोटे letter टा आइछि
देखियो एटारे से status report आछि आउ किछि letter अछि देखियो
नहीं
यदि instruction अछि मु कहि दोछि registry खोजिवो जे
probably
थिबे
they have sent it to the
it's a prisoner's petition to engage you.
yes
Okay. Lekho item number 263.
if lordship permit then only I can file the FIR.
No, let that later be
yes.
verified on
Yes.
Mr. H.S. Mishra.
It might have been come to the registry general.
Right.
I am told that this case number is he has not given the case number. That is why it is pending somewhere.
That he has instruction that prisoner's petition has been received to engage him in this case. Let the registry place the letter for consideration if the same is available in the next week.
Yes.
Okay.
Pardon to mention, my lord.
32.
Pardon to mention, my lord, item number 118. My lord, in this matter, on last date of hearing, my lord has directed the trial court for status report, and the status report is already on record, is showing in the cause list at flag X.
So, कौन करिवा पढ़िला बेलु we'll take up this matter when the matter reaches. We cannot take pick and choose the matters. Okay.
My lord, actually, this is for interim bail. Actually, the wife of the petitioner.
There are many cases in wife, son, father that are like they are ill. They are so yes. Call the matter serially.
My lord, item number 232. I am in VC. My lord,
Yes.
item number 232.
Yes. What do you want, Mr.?
This is anticipated bill. In this case, those against whom allegations they have already released on bail by the Court of
All right.
Sessions.
When the matter reaches, it will be verified by the London State Council and appropriate order will be passed. Have patience and wait till then. Yes.
Item number 1.
Please, Your Honor.
Offense under 302 34 IPC my lord. It's on custody.
You have received the case diary?
Yes, ma'am.
Whether it is the first application or earlier rejection?
Second application. Your lordship earlier occasion there to interim bill my lord. 3 months. In the meantime, my lord cancel the order.
In this man's name is Silu.
Aye.
His bail application was rejected in 777 of 2021 by the order dated 17/8/21.
Your lordship allowed interim bill my lord.
In which application?
My lord.
What is the BLAPL number?
BLAPL my lord 10,863 of 2022.
Okay.
You will allow 3 months for an interim bail, my lord. And the meantime, surrender before the learned court below, my lord.
I beg pardon, my lord. Item 12 is the co-accused. Both matter be taken together.
So on merit, your bail application has been rejected. Was rejected as per so and so, given liberty to renew the prayer after the examination of the material witness. In the meantime, eyewitness Jitendra Samal has been examined as PW4. He stated that so and so assaulted the deceased. Okay.
I beg pardon, I'm on VC, my lord. Item 12 and item 2 both are same, my lord.
So what is the now status of the case?
After interim bail, no one examined my information.
So how many witnesses have been examined?
Total 5 witnesses examined.
All right. The learned counsel for the petitioner submitted that he has instruction that only 5 witnesses have been examined so far in the trial court. And the petitioner approached this court last time for bail in BLAPL number 10863 of 2022. And he was granted interim bail for a period of 3 months. And after availing the same, he surrendered at right time. Learned counsel produces the copy of the bail order which is taken on record. In view of such submission, let a status report be called for. While submitting the status report, the learned trial court shall indicate as to whether the petitioner surrendered at right time after availing the interim bail period or not. Put up this matter along with kit number item?
12, my lord. Item 12, my lord. In the my rejection order, my lord, it is mentioned regarding my surrender.
With item number 12 and out of one
No, one of the co-accused has been granted anticipatory bail by this.
Two number of anticipatory bail.
We'll see that. Yes, next.
Item 3.
Yes.
Present petition is custody since 4th August 2023 for an allegation of offense under section 420 and other allied offences. Except in the meantime, 2 of the accused persons' bail application was allowed by the Senate court. As per the allegation against the present petitioner, present petitioner has been taken only 50,000 from the informant. That has been mentioned in the FIR. The main accused person has been taken 18 lakh from his account.
So who has been granted bail?
Lordship,
and have you got those bail order copies with you?
Lordship, BLPL number 437 of 2021, Raghunath Behera.
Hand over so that he will verify.
And another accused person, Sumyakant.
Raghunath Behera has been granted bail. It is your submission that Raghunath Behera is the main accused.
Let's see, main accused Somyakant Mahan.
Somyakanta and Subhasis took all the money. Petitioner.
Somyakanta has been released on bail.
Let's see, bail has been granted.
Are order kahi nale number kuhuntu kiछि to gote kahibe आजिकल तो सब अपलोड होची सौम्यकांत अच्छा महांती पेंडिंग देखौची अच्छा देखिले एटा कोन डिस्पोज ऑफ होचंती BLAPL 1000, 10,670, 10,670. Hala, 2022. It's pending case, Ajil. Yes. Scroll down, karo. 19/10/23 रे last time आस्तला देखिल order था. Share कर दियो तो देखो. See this order. Now it is visible to you. Learned counsel for the petitioner seeks some time to obtain instruction how much amount the petitioner can deposit at the initial stage and also by way of installment to clear the total amount as per charge sheet. Since it appears from the report received from the learned court below that the co-accused Raghunath Behera, who was directed to be released on bail with deposit of cash surety and subsequent deposit of cash on installment basis, has not been deposited anything in the court below. So how you submitted that Soumyakanta has been released on bail?
That's it. Raghunath has been granted bail.
Raghunath bail grant ହେଇଛି ତା ଦେହରେ ଯୋଉ condition ଥିଲା ନା cash surety ଦବ ଆଉ ତାପରେ installment basis ରେ ଦବ ଏ total ଦେଇନି କି ବାହାରିନି ଏଇଟା ହଉଛି ଗୋଟେ MBBS student ଆଉ KIT ରେ କରିବା ପାଇଁ ଆପଣ false assurance ଦେଇକିନି ତାଙ୍କଠୁ 17,50,000 ଟଙ୍କା seat କରେଇଦେବେ ବୋଲି MBBS course ରେ KIT ରେ ନେଇଛନ୍ତି ତେଣୁ you take instruction like this order
and another accept having 10 criminal antecedents.
Acha. The learned counsel for the is order achi setre kar de is your second portion, the operative portion. Learned counsel है ना तापर लिखिए learned counsel for the state submits that the petitioner has got 10 criminal antecedents. Let the learned counsel for the petitioner obtain instruction in respect of such antecedent and file a comprehensive affidavit relating to the status of those cases. 10টা ଯାକର number ନେଇ ଯାଆନ୍ତୁ ଯଦି ଆପଣଙ୍କ ପାଖରେ ନାହିଁ. Yes.
As per the FIR allegation, the present petitioner has been taken only cash of 50,000 and the other amount has been transferred to the account of the main account.
We'll see that, yes, sir. But he submits that you and that that person, they stand on the similar footing who has not been. Yes, next.
Item 4, Millers.
Item 4.
May I please, Millers? The petitioner is implicated in offense under section 21C of NDPS Act. Is in jail custody since 29/9/2020. In the meantime, the co-accused has been released by the coordinate bench of this honorable court. I have annexed that order.
What is the date of custody?
Custody, lordship, 29/9/2020.
And what is the stage of trial?
Stage 5 witnesses have been 3 witnesses have been discharged and 1 official witness has been examined.
No.
I have the certified copy.
Total number of witnesses examined in the trial court is
5.
5. And 3 have been declined.
Declined.
So 8. And what is the total number of witnesses as per charge sheet?
Charge sheet, lordship.
You have got the case diary? No. Learned counsel for the state seeks some time to obtain the case diary, so also to instruction about the criminal antecedent.
Lordship.
Learned counsel for the petitioner submit that the petitioner is in judicial custody since 29/9/2020. And he has instruction that only 5 witnesses have been examined in the trial court and 3 witnesses have been declined. In view of the submission, let a status report be called for so and so courtroom, and the learned counsel for the state shall obtain the
Lordship, case diary may be available.
The number diyo.
BLFL 12,809 of 22.
All right, he has noted down. You will find
12,809.
Yes.
Of 2022. Lordship, next week, Lordship.
Yes, it will come. Next.
Item 5.
Obliged.
May I please, Your Lordship? My Lord, 20B2C of the NDPS Act, my Lord, and the petitioner is in custody since 19th June 2021 and charge sheet submitted 12/3/2021, Your Lordship.
What is the date of custody?
19/6/2021.
And what is the status of the case?
My Lord, some of the witnesses have been examined, my Lord. In between, some of the accused persons also released on bail by the.
You have got the case diary?
No, my lord, has supplied.
All right. Learned counsel for the state seeks some time to produce the case diary and also to obtain instruction about the criminal antecedent. Learned counsel for the petitioner submits that the petitioner is in judicial custody since 19/6/2021, and he has instruction that only few witnesses have been examined. Let a status report be called for. Yes.
My lord,
Oblige, Your Lordship.
beg pardon, with this matter, my lord, another matter, son of the item number 5 as item 34.
34.
Today morning, I got the information that he has been referred to MKGC for treatment. So would your lordship allow us to file application for interim bail?
No, you are at liberty. There is no problem. This is to be listed along with serial number 34.
Yes, lordship.
Yes, next.
Oblige, Your Lordship.
Offense under section 20B subclause 2C of the NDPS Act. The accused petitioner has been implicated in this case basing on the statement of the co-accused, on whose statement the accused has been implicated. He has been acquitted, my lord. I answer 2. Another co-accused person on the similar footing has also been released on bail, my lord.
No, this is a case of the year 2013.
My lord.
And when you were apprehended?
10/9/2023, my lord.
So after 10 years, you are an
My lord, order of NBW was stayed before this honorable court, by this honorable court, my lord. Since 2017, my lord.
So you have got the case diary?
Yes, ma'am.
Okay. Verify that acquittal judgment and say that whether his only implication is based on confessional statement of co-accused or anything else is there. All right. The learned counsel for the state submits that he has received the case diary. Submission is made on behalf of the learned counsel for the petitioner that the only material available on record against the petitioner is the confessional statement of co-accused before police, who after facing trial has been acquitted. The learned counsel handed over the copy of the acquittal judgment to the learned counsel for the state in court today, who seeks some time.
My lord, already I have filed, my lord. Annexed the judgment.
He has annexed it. Will verify the same. Raise this matter next week. Yes.
Item 7.
May it please, Your Lordship.
Yes.
My lord. Here, my lord, this is the second journey of the petitioner, my lord. Here, the petitioner's bail application rejected, white order dated, my lord, 19/9/2022. Your Lordship may kindly peruse BLPL number 5361 of 2021.
Where is that order? Have you given that order?
No, my lord, I have not given. I think tagged with that matter. 5361 of 2021. The first bail application of the petitioner.
No, is it there? 5361 kind. Only one bail application has come, that is 523 of 2019.
That bail application, Your Lordship, granted in the year 2019. Another co-accused bail application. Your Lordship allowed
that. That is not there. You file it. Copy of that, sir. You have received the case diary?
Yes, sir.
So, if you have got the copy of that bail order, please file it so that State Council will go through the same. We are taking up this matter next week. All right. The learned counsel for the petitioner submits that that is your earlier bail application or what?
That is your earlier.
The petitioner earlier approached this court for bail in BLAPL number
5361 of 2020.
5361 of 2021. And the same has been disposed of, and you will supply the copy of the order to the Land and Council for the state. List this matter next week. Yes.
Grateful.
May I please, my lord?
Item 8.
May I please, my lord? I am from Denkanal VC, my lord.
Yes.
This is an application of well. Of course, the second one, first one being withdrawn.
Item 9.
May I please, madam? Petitioner is custody since 13th September 2022. The charge sheeted for the offense 498 302 201 34 of IPC.
You have received the case diary?
Yes. Madam, the allegation is, madam, the accused is the brother-in-law of the deceased. The husband of the deceased lodged an affair, initially lodged an missing affair. Thereafter, subsequently, the present affair was filed.
What is the date of custody you said?
13th September 2022. Madam, there is no eyewitness in the case. It's a case of circumstantial evidence, madam. The implication is the one Sudarshan Pradhan is the employer of both the younger brother, present accused person, and the elder brother, who is the deceased. The present accused person disclosed before the employer that I had killed my sister-in-law. That is indicated in the FIR lordship.
But while granting bail to the co-accused persons in BLAPL number 3502 of 23,
yes,
it is mentioned that the main allegation is against you, who is another son of the petitioners and younger brother of the informant, and not only assaulted the deceased but strangulated her by means of a napkin, and the cause of death was on account of craniocerebral injuries, also strangulation. And so far as them is concerned, that was only under section 201. So that is how they were granted bail. So against you, the accusation is something different.
Yes, 27 Evidence Act, there was a confessional statement of the accused before the police, and there was leading to discovery to the
What was recovered at your instance?
The dead body,
recovered.
Dead body?
Yes.
So where the dead body was lying?
It was in the, they have
ଚୁଡି ମାରି ସବୁକୁ ଆମ ଘର ସାମ୍ନାରେ ଆମ ଗଛ ତଳେ ପୋତି ଦେଇଥିଲେ। ମାଟି କୁଦି ଦେଲୁ।
ତାକୁ ଆଗେ ମାରିଛନ୍ତି, ତାପରେ ତାକୁ ତଣ୍ଟି ଚିପିଛନ୍ତି, ତାପରେ ତାକୁ ନେଇ ପୋତିଛନ୍ତି ଆପଣଙ୍କର, ଏବଂ ଲିଡିଂ ଟୁ ଡିସ୍କଭରି ଦେଇଛନ୍ତି। ଇଟ୍ ଇଜ ୱିଦିନ୍ ୟୋର ସ୍ପେଶାଲ ନଲେଜ। Your parents were released on bail because the only material is 201. So you cannot claim parity with them. How can against you the allegation is different? So after the witnesses are examined, if something is so then you can renew the prayer. Now the trial has not commenced.
Not commenced, sir.
So all right. In view of the available material on record, though the learned counsel for the petitioner claimed parity with the co-accused persons Chaitu Kindo and Sukanti Kindo were granted bail in BLAPL number 3502 of 2023, but after going through the bail order of the co-accused persons, I am of the view that the petitioner is not similarly situated, and in view of the available material on record and the post-mortem report finding, and particularly the evidence relating to discovery of the dead body at the instance of the petitioner under section 27 of the Evidence Act, I am not inclined to release the petitioner on bail. The petitioner is at liberty to renew the prayer for bail after examination of the material witnesses. Now the case is pending before the JMFC.
No, Lord, it has been committed.
It has been committed. The learned trial court shall do well. Charge frame?
Not yet frame.
To expedite the framing of the charge and obtain a list of material witnesses from the learned public prosecutor and take every step to examine them at the first instance. Yes, copy of the order be communicated to the learned trial court for compliance. Yes.
Item 10.
is my fourth journey.
May I please, Your Lordship? I invite Your Lordship's kind attention to paragraph 55 and 56 at page 104 to 123.
Whose evidence?
PW3.
Paragraph number
55 and 56. Page 104 ରୁ ଆରମ୍ଭ। The witness has deposed.
Yes. What is the page number of that?
104.
55. Yes.
Bottom. The witness has deposed about the qualification and disqualifications of a candidate right from the Constitution and provisions of the RP Act 1951. Article 173 of the Constitution of India prescribes as to when a person shall not be qualified. Your Lordship got it?
Yes, sir.
My Lord. Kindly see Exhibit 38. As per Exhibit 38, if I found any defect of a substantial character in the nomination paper of any candidate, I am to reject the same, and if I found that the defect, if any, is not of a substantial character, the nomination papers of the candidate are to be accepted as valid.
Just a minute. Exhibit এটা কাହିଁ sir?
Paragraph 55.
55 से exhibit 38 टा बरा देखिए मध्ये not necessary. Okay. Then उस paragraph टा देखिए वो.
आगे.
55 ର ସେଟା ସେ କହିଛି।
हाँ ठीक है जी पढ़ो।
Starting ରୁ କହିଛି।
Then that is there. I thought that you want me to see
No.
Exhibit 38.
As per Exhibit 38.
Prosecution petitioner तरफ जो exhibit हुआ, exhibit कहीं? It's the issue. Yes, it's all right. Come to that. Yes.
Article 173 of the Constitution of India prescribes as to when a person shall not be qualified to be chosen to fill a seat in the legislature of a state. According to Article 173A of the Constitution of India, a person shall not be qualified to be chosen to fill a seat in the legislature of a state unless, Your Lordship may kindly come to the Constitution.
That is quoted there, Mr.
My Lord. He, one, is a citizen of India, and two, makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the third schedule. In the nomination paper of the respondent in Form 2B, under its Part 3, against item number A, the respondent has declared that he is a citizen of India, and no one has contradicted this statement of the respondent. Secondly, respondent has subscribed oath before me after presentation of his nomination to me on 2/4/2019 and before the date previous to the date of scrutiny, which would be evident from Exhibit BJ and Exhibit T. And therefore, he is qualified to be chosen to fill a seat in the legislature of the state of Orissa as prescribed under Article 173A of the Constitution of India. That is one of the requirements of the Constitution.
No, Mr. Mishra, the thing is that what is there, what you have filled in that nomination paper, that is not the question here. What you have omitted, what you have deleted, whether that is of substantial in nature or ସେଇଟା ମେନ୍ ଆପଣ ଯୋଉଟାକୁ ଫିଲ୍ ଅପ୍ କରିଛନ୍ତି ସେଇଟା ତ କେହି ଡିସ୍ପ୍ୟୁଟ କରୁନାହାନ୍ତି ନା ଆପଣ ଏଗୁଡା ଫିଲ୍ ଅପ୍ କରିଛନ୍ତି ବୋଲି ଯୋଉଟାକ କାଟି ଦେଇଛନ୍ତି
ଯେ ସିଏ ଯାହା ଫିଲ୍ ଅପ୍ କରିଛି ସେଇଆ କନଷ୍ଟିଟ୍ୟୁସନ ରେ ଆରପି ଆକ୍ଟ ରେ ଦରକାର। I have found it valid।
ସେମାନେ କହୁନାହାନ୍ତି
ତାଙ୍କର କୌଣସି ନାହିଁ reason to reject his nomination।
ସେ ଆପଣ ଯୋଉଡାକ ଫିଲ୍ ଅପ୍ କରିଛନ୍ତି କନଷ୍ଟିଟ୍ୟୁସନ ଅଛି ସେଗୁଡା ଫିଲ୍ ଅପ୍ କରିବାକୁ ଆପଣ ଫିଲ୍ ଅପ୍ କରିଛନ୍ତି ଠିକ ଅଛି। ତାଙ୍କର ପ୍ରଶ୍ନ ହଉଛି ବା ତାଙ୍କର କେସ୍ ହଉଛି ଯୋଉଗୁଡାକ ଓମିଟ୍ କରିଦେଇଛନ୍ତି ଡିଲିଟ୍ କରିଦେଇଛନ୍ତି ସେଗୁଡାକ ଆପଣ ସେ ଟାଇପ ର କରିବାର ନଥିଲା। ତା ଉପରେ
ବି ଏଇଥିରେ କହିଛନ୍ତି ମୁଁ ପ୍ଲେସ୍ କରି ଯାଉଛି ରେଲେଭାଣ୍ଟ ପୋର୍ସନ ଗୁଡାକ ବି ଆପଣ ମାର୍କ କରିଦେବେ। In support of the declaration made by the respondent in his nomination in Form 2B under its Part 3 against item number A, he is a citizen of India. He has also submitted Exhibit AZ, photocopy of the final voter list, Exhibit BC, photocopy of voter identity card, Exhibit BD, photocopy of PAN card, Exhibit BE, photocopy of Aadhaar card in his first set of nomination. In support of the declaration made by the respondent in his nomination in Form 2B under its Part 3 against item number A, that he is a citizen of India, he has also submitted Exhibit BU, photocopy of final voter list, Exhibit BX, photocopy of identity card, Exhibit BY, photocopy of PAN card, Exhibit BZ, photocopy of Aadhaar card in his second set of nomination. In support of the declaration made by the respondent in his nomination in Form 2B under its Part 3 against item number A, that he is a citizen of India, he has also submitted Exhibit CK, photocopy of the final voter list, Exhibit CN, photocopy of voter identity card, Exhibit CP, photocopy of PAN card, and Exhibit CQ, photocopy of Aadhaar card in his third set of nomination. In support of the declaration made by the respondent in his nomination in Form 2B under its Part 3 against item number A, that he is a citizen of India, he has also submitted Exhibit DB, photocopy of final voter list, Exhibit DE, photocopy of voter identity card, Exhibit DF, photocopy of PAN card, and Exhibit DG, photocopy of Aadhaar card in his fourth set of nomination. Article 173B of the Constitution of India prescribes that a person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he is in the case of a seat in the legislative assembly not less than 25 years of age. The respondent has mentioned his age to be 53 years in his nomination paper in Form 2B under Part 3, Item B. Therefore, the respondent is qualified to be chosen to fill a seat in the Legislative Assembly.
Mr. Mishra, I have already gone through. Please come to page number 114. all those things have gone through. These are all okay for you. There is no problem in that. Please come to 114. Nobody is disputing that. Yes, come to page number 114.
114. Okay. 114.
Yeah, the first proviso, you read that. Yeah.
The first proviso to subsection 1 of section 33 of the RP Act 1951 is not applicable for the respondent as he was set up by a national recognized political party. There is an instruction in the nomination paper in Form 2B itself appearing above Part 1 to strike off Part 1 or Part 2 below, whichever is not applicable. The respondent, being a candidate of the national recognized political party, is required to use Part 1 of Form 2B and to strike off or delete Part 2 of Form 2B. The respondent has filled up Part 1 and deleted Part 2. This is one of their allegations of his nomination paper in Form 2B. By deleting Part 2 in his nomination paper in Form 2B, the respondent has complied with the provisions of law as well as the instructions given in the nomination form itself. This is material. Deletion of Part 2 in the nomination paper in Form 2B by the respondent is not a defect of substantial nature.
That's right.
Your Lordship may kindly.
Yes, ma'am.
The second proviso to 33(1) of the RP Act 1951 prescribes that no nomination paper shall be delivered to the returning officer on a day which is a public holiday. The respondent delivered his 4 sets of nomination papers in Form 2B on 2/4/2019, which was not a public holiday, place of submission of nomination paper. The election petitioner Devashish Samantray as well as Bharatiya Janata Party candidate Mr. Samir De and Akhil Bharat Hindu Mahasabha candidate namely Sital Kinnar also filed their respective nomination papers on 2/4/2019, which would be evident from Exhibit AK. So it was submitted at the right place. Section 33(2) of the RP Act 1951 is not applicable in the case in hand, as the 90 Baravati Kotak Assembly constituency is a general seat and not reserved for SC and ST candidates, and therefore the nomination paper does not require a declaration by a candidate specifying the particular caste or tribe of the candidate. 33(2).
One thing, Mr. Mishra, just it is for you and of course for Mr. Kanungo. It is their witness.
Mine.
And one of the pleading is that he has deleted Part 2. And he should not have done it.
Yes.
And for which his nomination paper is to be
Acceptance
rejected.
of his nomination
is
paper
illegal.
Illegal and improper.
Their witness PW3 has stated that deletion of Part 2 in the nomination paper is not a defect of substantial character.
Two things. It is not a defect at all.
At all. The defect of substantial character.
Mine. Cross examination.
Because at one place he has stated
not permissible.
That it is not permissible. I have power to condone it if it is of this nature. And when he has made such a statement that deletion of Part 2 in the nomination paper is not a defect of substantial character, then whether it was not the duty of the examination in chief who was conducting the election petitioner to make an application for re-examination. I'm asking
On
you,
this aspect.
on this aspect,
Yes.
that in at one place you are telling that he has no power, it cannot be deleted, it cannot be altered, or it is illegal, and at another place you are
Not
telling
permissible.
not permissible. You are telling.
ଏଠି ସେ ଯୋଉ କହୁଛନ୍ତି the respondent has filled up part 1 and deleted part 2
से
of his nomination paper.
काली से जो लाइन टा देखौथिले कोर्ट क्वेश्चन ने कहलानी जे तांकर डाउनलोड कला परे कोनोसी पार्ट डिलीट करी पारिबे नाही ए गोटे से को पेज रे काली पढुथिले परा जो दैट इज कोर्ट क्वेश्चन ने से कहिले 69 अच्छा डिलीशन इज इम्परमिसिबल केस 69 69 दे बाहर करो 69 right, that is the first question itself. First question re deletion re se कहउछन the question is like this: whether while downloading the nomination paper from the official website a candidate is legally permissible to make alteration, deletion, modification, tampering of the same and file it after filling the same. No, it is not permissible.
It's not permissible.
So it is not permissible, and he has got some power under 33(4) that he can
ignore it,
ignore some of the that clerical etc etc. And now he has stated to your questions in this page number 114 that this deletion of part 2 in the nomination paper in form to be by the respondent is not a defect of substantial character.
That purple line can be most material. By deleting part 2 in his nomination paper in form 2B, the respondent has complied with the provisions of law as well as the instructions given in the nomination form itself.
So on this question,
so what your lordship's query is, से जो पूर्वे रे कहिले डिलीशन of his own accord जो चारटा जिंस of his own accord he has no power to delete it, but a candidate can delete if it is permissible under law and is permitted under the instruction of the nomination form itself. That is what is justified under this section. So it was incumbent upon the election petitioner, as your lordship points out, that file an application to recall him and to cross-examine him, confronting these two portions.
It's a two different things that that is for explaining the things. So re-examination purpose is that. So if somebody has not availed it, देखिए evidence actor.
कोर्ट अन्य विषय पर चलते मैं ସେଇଟା କାଇଁ ଦେଖେ
This 138 says that re-examination shall be directed to the explanation of matters referred to in cross-examination.
137 and 138 may be read together.
Right. And if new matters is by permission of the court introduced in the re-examination, the adverse party may further cross-examine.
I have the right to cross-examine him.
So
they have not availed.
They have not availed
this opportunity.
Right.
By filing an application under 138.
Right.
To recall him and cross-examine him.
And moreover, it is their witness.
It is their witness. And the primary aspect, your lordship may kindly note that it is absolutely incumbent upon the election petitioner to plead these facts in the pleading itself. There is no pleading.
So moto deleted the part 2. Whether part 2 is required to be filled up by the respondent.
And deletion is not permissible. সেটা কই না।
Yes.
Section 33(2) of the RP Act 1951 is not applicable in the case in hand. As the 90 Baravati Kotak Assembly constituency is a general seat and not reserved for SC or ST candidates, and therefore the nomination paper does not require a declaration by a candidate specifying the particular caste or tribe of the candidate. Section 34 of, in terms of Section 34 of the RP Act 1951, which requires a candidate to deposit a sum of rupees 10,000 as security deposit, the respondent has deposited the amount by Exhibit AX in Exhibit 38/3. The nomination paper in Form 2B in Part 3, there is a declaration which a candidate is required to furnish. That is, I further declare that I am a member of caste, such and such caste and tribe, which is a scheduled caste and scheduled tribe of the state, of Amuka state, in relation to Amuka area in this state.
Now the next line are very important.
Minor. The respondent has deleted this portion of his, this portion in his 4 sets of nomination paper by Exhibit 39, 40, 41, 42. There is a mention in Exhibit 38/3 in Part 3 at the end by giving score out this paragraph if not applicable. So accordingly, I have deleted it.
It is used as score out.
Score out. Okay. I say score out.
And deletion is one.
Score up. Deletion is one thing, and he has also stated in his evidence to that effect. Right. This particular paragraph, which has been deleted by the respondent in his nomination paper Exhibit 39, 40, 41 and 42, is not applicable to the respondent.
No, another thing, Mr. Misra, when their witness has stated in the cross-examination that deletion and striking off is one and same.
Same thing.
Have they should have clarified it by also by way of re-examination.
Yes. Yes.
That it is not the same thing.
Yes.
Deletion that yes. They have not done.
Exactly.
Yes.
That point may kindly be noted.
That is stated in the cross-examination, na?
Mild.
That striking off and deletion is one and same.
Mild.
Yes.
Score out this paragraph if not applicable, and score out the word not applicable. This particular paragraph, which has been deleted by the respondent in his nomination paper Exhibit 39, 40, 41 and 42, is not applicable to the respondent in view of Section 5A and Section 33(2) of the RP Act 1951. The respondent has never claimed himself to be a member of scheduled caste or scheduled tribe category. Deletion of the above subparagraph in part 3 of the nomination paper in form to be filed by the respondent is not a defect of substantial character.
Just correct.
In Exhibit 38/3, in Exhibit 38, in part 3, there is an instruction to strike out CI or CII below, whichever is not applicable. And the respondent in his nomination paper has deleted CII only, as only CI is applicable to him and CII is applicable for a candidate of a registered unrecognized political party and independent candidate. ତେଣୁ ସେ ଯୋଉ କହୁଛନ୍ତି ଏଇଟା ଡିଲିଟ କରିଦେଇଛନ୍ତି, that is not a defect. ଲିଡିଂ ରେ କହିନାହାନ୍ତି, ଯୋଉ ଏଭିଡେନ୍ସ ରେ ଆଣିଥିଲେ ସେଇଟାକୁ ବି ଆମେ ଏଠି କ୍ଲାରିଫାଇ ସେ କରିଦେଇଛନ୍ତି କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ।
ସେଇ ବିଷୟରେ ଓନ୍ଲି କହିଛନ୍ତି ପ୍ଲିଡିଂ ରେ କି ଇଟ୍ ଇଜ ନଟ୍ ଇନ୍ ପ୍ରେସ୍କ୍ରାଇବ୍। କଣ ଡିଲିଟ ହେଇଛି କଣ ହେଇଛି ଇଟ୍ ହାଜ ନଟ୍ ବିନ୍ ସ୍ପେସିଫିକାଲି mentioned in the
part 3 ବିଷୟରେ ସ୍ପେସିଫିକାଲି ପ୍ଲିଡିଂ ନାହିଁ।
କିଛି
it is not in prescribed for who person deletion ହେଇଛି and that deletion is defect of a substantial character ସେ କଥା ପ୍ଲିଡିଂ ରେ ନାହିଁ।
part 2 ବିଷୟରେ ବି ନାହିଁ, part 3 ବିଷୟରେ ବି ନାହିଁ। क्रॉस एग्जामिनेशन रे स्टेटमेंट देला पर भी एप्लीकेशन टू रिकॉल एंड क्रॉस एग्जामिन नहीं। Proviso to Rule 4 of Conduct of Election Rules 1961 prescribes that a failure to complete or a defect in completing the declaration as to symbols in a nomination paper in Form 2A or Form 2B shall not be deemed to be a defect of substantial character within the meaning of subsection 4 of section 36. In my view, deletion of C2 in part 3 in the nomination papers filed by the respondent is not a defect of substantial character. এটা টিকে স্যার নোট করো আগে। ସେ ଯୋଉ ପ୍ରୋଭାଇଜୋଟାକୁ ରେଫର କରୁଛନ୍ତି ରୁଲ 4 ର proviso to rule 4 that is not exhaustive, that is only illustrative. The respondent in his nomination paper in Form 2B this part is portion relates to part 3A,
right,
minor. The respondent in his nomination paper in Form 2B, that is 39, 40, 41 and 42 has mentioned in part 3A under item number 2 that he is not holding any office of profit under the government of India or the state government, and further he has mentioned in part 3A under item number 6 that he was not dismissed for corruption or for disloyalty while holding office under the government of India or the government of any state. Therefore, the respondent is not disqualified under Section 9 of the RP Act 1951, and he shall not be deemed not to be duly nominated as a candidate in the election in question as prescribed under subsection 3 of Section 33 of the RP Act 1951.
Okay, Mr. Just skip over, come to the next page, page 118.
My lord.
Please come to the second subparagraph.
My lord.
118, second subparagraph. That is, it reads start as proviso to subsection 4. 118. 118 second subparagraph.
My lord, my lord. Proviso to subsection 4 of Section 33 of the RP Act 1951 provides that as returning officer I can permit any misnomer or inaccurate description or clerical, technical or printing error to be corrected, and when necessary, direct that such misnomer, inaccurate description, clerical, technical or printing error in the electoral roll or in the nomination paper to be overlooked. By exercising my power conferred under the proviso to subsection 4 of Section 33 of the RP Act 1951, I have overlooked alleged defects, deletion, omission in the nomination papers in Form 2B of the respondent, as the same were not defects of substantial character, and such alleged defects, deletion, omissions being coming under category of misnomer, inaccurate description, clerical, technical or printing error, as a returning officer, I have overlooked the same. Here is a positive statement. Positive statement.
He has no re-examination, so this has remained unchallenged.
Remain unchallenged. This same may kindly be taken note.
So again, another thing is that suppose he has made such a statement in the cross-examination that I have got this power, and even if this deletion has been made, since I find that these are not of substantial
character, defect of substantial
yes, I have overlooked it because exercising my power under Section 33(4). Now, if law permits him that he has got that sort of power to condone this or to overlook this deletion part, then obviously it is, but if the law says that no, this would not come, this deletion would not come within clerical misnomer, then can only otherwise the witness has stated in your favor. Though it is their witness, he has stated in your favor.
They have to justify.
They have that to justify. Law says, even he has made such a statement, law says that no, it doesn't come within.
This no part has to be justified by them.
Right. All right.
Subject to my reply.
Right. Obviously.
In 3 sets of nomination papers, that is Exhibit 39, 40, 41, in Part 3A against item number 1, where the candidate, if convicted of any offences under subsection 1 or of contravention of any law specified in subsection 2 of Section 8 of RP Act 1951, or has been convicted for any other offences for which he has been sentenced to imprisonment for 2 years or more, the respondent has mentioned no.
Obviously, by that time, that judgment had not come.
Right.
It came sub, and but the sentence is 2 years. In that case, all right.
My lord, in pleadings, with respect to Part 3A, Their pleading is the columns are not at all filled up and it is left blank.
In so far as 3A is concerned. But we find that the columns have been filled up, but something is missing. That means second part. Because it lies, if it is answer is yes,
then
you are if the answer is no, then
What
there
is
is
pleadings? It is that the
okay.
not at all filled up and the columns have been
Just,
left
just a minute. Part 3A, election petitioner pleading, not at all filled up.
Not at all filled up.
Can you just at this juncture point out that very page where that has been mentioned in the election petition? The election petition of Harper?
Page 7, my lord.
Just a minute.
Page 7 of the election.
Wait. Election petition. Page 7.
Page 7, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12 number line from the top.
Acha, just a minute. Part eta yellow karo. Part 7, 3A of the nomination paper filed by the respondent has not been filled up by the respondent. The columns of Part 3A of the nomination paper has been left blank and columns from 3 to 9 are also not in prescribed form to be. This is so far as only these portions are there for Part 3A.
এবং কোন ফিল আপ করে নাহাନ୍ତି সেই পার্টটা ବି କହିନାହାନ୍ତି।
Page 7 of election petition.
12th line from the top.
12th line from top. ଆଉ ଥରେ ପଢିଲେ ଏଟା ଜଣା ପଡୁଛି Part 3A of the nomination paper filed by the respondent has not been filled up by the respondent. Acha. The columns
it may have two meanings. Just not filled up by the respondent. ଆଉ କିଏ କରିଥାଇପାରେ?
The columns of Part 3A of the nomination paper has been left blank. The columns from 3 to acha.
ତାକୁ ତିନିଟା ଥାକରେ ମାଇଲ ପଡନ୍ତି। ଗୋଟେ ହେଉଛି not filled up, ଗୋଟେ ହେଉଛି has been left blank, ଆଉ then 3 to 9 are also not in prescribed form too. How it is not in prescribed form?
That has not been pleaded.
No, but in fact, if we see that for Part 3A,
nomination paper itself,
that indicates that it has been filled up to some extent. That is, first line ta filled up.
Have been filled up.
All the columns ro prathama line ta ko apan fill up karijanti.
Second line ta if
second ta if yes,
not necessary to be filled. I have deleted it.
Say fine. Okay. Yes.
And my submission in this aspect before your lordship would be that Honorable Supreme Court's decision in Jitu Patnaik's case stares at their face. ଗଲେ ରେଜିଷ୍ଟରରେ ସାଇନ୍ କଲେ, ଭୋଟିଂ ଚାମ୍ବରକୁ ଗଲେ, ଭୋଟ ଦେଲେ କି ନାହିଁ ମୁଁ ଆଣ୍ଡ ଭୋଟେଡ ଏଇ ଗୋଟିଏ ୱାର୍ଡ ମୁଁ ଛାଡି ଦେଇଥିଲି। I will place that decision in 3 sets of
no specific reading that what has been left out or what has been not filled up.
Not pleaded. Left blank.
And how it is not in prescribed form, columns from 3 to 9
are not in prescribed form.
ଆଉ ଗୋଟେ କଥା ଏକ୍ସାମିନେସନ ଇନ୍ ଚିଫ୍ ରେ ମଧ୍ୟ ଏଇ 3 to 9 କଣ କଲମ ଟା ଖାଲି ରହିଛି ସେଟା ବି ସେ ଆଣିନାହାନ୍ତି।
ପ୍ଲିଡିଂ ରେ କହିନାହାନ୍ତି, ଏକ୍ସାମିନେସନ ଇନ୍ ଚିଫ୍ ରେ ବି ଆଣିନାହାନ୍ତି।
ଯାଦ୍ୱାରା ଆମେ କ୍ରସ୍ ଏକ୍ସାମିନେସନ ରେ ଗୋଟି ଓମିଶନ କୁ କହିକି that is not substantial defect ବୋଲି elicit କରିଛୁ।
नो आपण जदि आमे पार्ट 3 रो ओरिजिनल एटा को देखिबू 3A रो ताहले कॉलम नंबर 3 to 9 पढ़िले आमे एवं कंपेयर कले जो एग्जिबिट 39 स्वांसो आमे पाइबू जे कॉलम नंबर 3 to 9 रो फर्स्ट लाइन टा लेखा आइछि एवं
उत्तर दिया है,
उत्तर दिया है। सेकंड लाइन टा
डिलीशन है अप टू कॉलम 8।
हाँ,
कॉलम 9 में अच्छी सेकंड सेंटेंस।
अच्छा, सेकंड सेंटेंस
प्लीडिंग भी करेक्ट नहीं है। 3 to 9
अच्छा
इज नॉट करेक्ट। 3 to 8 रो सेकंड सेंटेंस डिलीट।
आपण कहवा कथा जे ए प्लीडिंग रहिबा दरकार थिला जे 3 to 9 एमिति बे गेल होबनी। 3 to 9 दरकार
8 पर्यंत गुटे 9 पे
3 to 8 केवल प्रथम
ये 9 जो कहले से नॉट प्रेस्क्राइब फॉर्म ये 9 टा प्रेस्क्राइब।
अच्छा,
जहां अछि एग्जिबिट 38/3 रे 9 रे से अछि। बट
3 to 8 प्लीडिंग करिवार थिला आपनकर कहवा अनुଯାयी 3 रे केवल फर्स्ट लाइन टा माने देखै जंदी ता पर जो एटा से माने देखै ना
एंड सेटा न देखला फल रे इट इज सब्सटेंशियल डिफेक्ट।
ओके, यस।
Now
you are placing that PW3's evidence.
518 number page.
518 number page.
Plus
in 3 sets of nomination.
Just.
PW3 रो 118 number रो last सब paragraphs.
Yes, I got it. 118 page.
In 3 sets of nomination papers, that is exhibit 39, 40 and 41.
Yes. Got it. Yes.
In part 3A against item number 1, where the candidate, if convicted of any offences under subsection 1 or for contravention of any law specified in subsection 2 of section 8 of the RP Act 1951, or has been convicted for any other offense or offences for which he has been sentenced to imprisonment for 2 years or more, the respondent has mentioned no. And therefore, he has not filled up I to XII subcolumn जो गुड़ा के तापर sentence गुड़ा XII appearing under item number 1. However, in exhibit 42, in part 3A against item number 1, where the candidate, if convicted of any offences under subsection 1 or for contravention of any law specified in subsection 2 of section 8 of the Act, RP Act 1951, or has been convicted for any other offences for which he has been sentenced to imprisonment for 2 years or more, the respondent has mentioned no. He has filled up I to XII appearing under item number 1 as NA in all the clauses except clause VIII, where he has mentioned no. The non-filing of I to XII appearing in item number 1 under part 3A in exhibit 39, exhibit 40, exhibit 41, or mentioning as NA or no in the clause under I to XII in exhibit 42 is not a defect of substantial character, particularly when the respondent has mentioned as a no against item number 1. Moreover, there was no objection to the declaration of the respondent by anybody before me contradicting such statement. As returning officer, I have exercised my power conferred under the proviso to subsection 4 of section 33 and subsection 4 of section 36 of the RP Act 1951.
Yes, 36 4
not of substantial character. 33(4) and 36(4). And I have overlooked such non-filing as the same were not the defect of a substantial character and accepted all 4 sets of nomination papers of the respondent. The respondent, in his 4 sets of nomination papers in Form 2B, that is Exhibit 39, Exhibit 40, Exhibit 41 and Exhibit 42 under item number 3 of Part 3A, where a candidate is required to furnish information whether he had been declared insolvent by any court, has mentioned no. In the prescribed format in Exhibit 38/3, after the first sentence under item number 3 of Part 3A, if the answer to the first sentence would have been yes, the candidate in the second sentence is required to mention whether he has been discharged from insolvency. This second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence. And the second sentence is not applicable to him. According to me, the deletion of the second sentence under the item number 3 of Part 3A by the respondent is not a defect of a substantial character, which I was convinced after exercising my power conferred under the proviso to subsection 4 of section 33 and subsection 4 of section 36 of the RP Act 1951. Moreover, there was no objection to such declaration of the respondent by anybody before me contradicting such statement. The respondent in his 4 sets of nomination papers in Form 2B, that is Exhibit 39, 40, 41 and 42 under item number 4 of Part 3A, where a candidate is required to furnish information whether he is under alliance or adherence to any foreign country, has mentioned no. In the prescribed format in Exhibit 38/3, after the first sentence under item number 4 of Part 3A, if the answer to the first sentence would have been yes, the candidate in the second sentence is required to give details thereof. This second sentence has been deleted by the respondent as he has mentioned no to the answer against the first sentence. And the second sentence is not applicable to him. According to me, the deletion of the second sentence under item number 4 of Part 3A by the respondent is not a defect of substantial character, which I was convinced after exercising my power conferred under the proviso to subsection 4 of section 33 and subsection 4 of section 36 of the RP Act. Moreover, there was no objection to such declaration of the respondent by anybody before me contradicting such statement.
The similar thing has been stated because all those are copy paste except that particularly. So you skip over the next 5, 6, 7, then 8, also same. 9 টা কোন কৌতলে? Please come to that page number 122. 122 ର last sentence টা. Last sentence কହୁଛି, last paragraph টা. 8 item number 9 ଉପରେ question ଅଛି.
the respondent in his 4 sets of nomination papers in Form 2B, that is Exhibit 39, 40, 41, 42 under item number 9 of Part 3A, where a candidate is required to furnish information whether he has been disqualified by the Commission under Section 10A of the RP Act 1951, has mentioned no. In the prescribed format in Exhibit 38/3, after the first sentence under item number 9 of Part 3A, if the answer to the first sentence would have been yes, the candidate in the second sentence is required to give the date of disqualification. The second sentence has not been filled up by the respondent in Exhibit 39, 40, 41, whereas in Exhibit 42, it has been mentioned as an NA. According to me, the non-filling of the second sentence under item number 9 in Part 3A by the respondent in his 3 sets of nomination papers, that is 39, 40, 41, or mentioning NA in Exhibit 42 is not a defect of substantial character, which I was convinced after exercising my power conferred under the proviso to subsection 4 of section 33 and subsection 4 of section 36 of the RP Act 1951. Moreover, there was no objection to such declaration of the respondent by anybody before me contradicting such statement.
So he makes it very clear.
Very clear.
That this 3 year जो 3 to 9 पर्यंत जो कलम से जेहेतु प्रथमटारे आंसर नो बेली लिखिचंती तेणु आ सेकंड लाइन तंकर फिलिप करिवार किछि जस्टिफिकेशन नथिला तेणु सी जो डिलीट कर देले सेही पोर्शन गुडाको that was
not a
defect of substantial.
9 second sentence.
9 second sentence ta gotte kere achi NA roichi au अन्य
is not correct. 3 to 9 you call column 3 to 9 not filled up.
not
in
se
right form. That is not correct.
Okay, that is not correct so far as exhibit 42 is concerned. But in
all exhibits
kemti apon
42 re NA lekhile second sentence rakhile ebong second sentence against NA lekhile 40 39 40 41 ne kichi lekhile
kichi lekhile not in prescribed form. It is in prescribed form, but that column number 9 ta katha kohuchan
also not in prescribed
9 ta in prescribed form, but the answer given in one set the answer is given as NA, whereas in the other 3 sets nothing has been mentioned.
Nothing has been given.
If my Lord will see other nomination papers which have been marked as exhibits, second sentence by all the candidates has not been filled.
If they have mentioned is no, so there is
no necessity.
If yes, then
proceed to answer.
Proceed to. So
then your lordship may kindly come to paragraph 59.
No, question now it comes that suppose there would have been any judgment, let us say, that even if you mention no in the first line, still then you cannot omit or delete the second line.
Yes.
Then
it will matter relevant.
Okay.
Rather, judgment achi 8 case re part 2 is not relevant for the candidate. Part 2 is not relevant for a candidate who has been set up by a recognized national recognized political party or state recognized.
ଏବେ ଯୋଉ nomination paper my lord CII ରହିଛି omitted ହେଇଛି ସେତେବେଳେ ଥିଲା nomination ସେଟା BII ସେଥିରେ ମଧ୍ୟ honorable apex court କହିଛନ୍ତି BII is not relevant for the candidate. BI is relevant for the
candidate.
No, obviously for that. So let us stop today here. So we'll take up on, you said that on tomorrow there is some problem.
ମୁଁ କହୁଛି ମଙ୍ଗଳବାର, ବୁଧବାର, ଗୁରୁବାର, ଶୁକ୍ରବାର 4 ଦିନ କଣ୍ଟିନ୍ୟୁଅସଲି ନିଅନ୍ତୁ।
ସୋମବାରଟା କହୁଛନ୍ତି
ଫାଷ୍ଟଟା ଆପଣଙ୍କର ୱିକଡେ ବହୁତ ବାହାରରେ ବି ଆମେ ସମସ୍ତେ
ଦେଖୁଛନ୍ତି
ଆଜ୍ଞା ଆଜ୍ଞା
300 କେତେ ମ୍ୟାଟର ଲିଷ୍ଟରେ ଅଛି, ମୁଁ ଜମା 10ଟା ଧରି ପାରୁଛି। ଆସି ମେନସନ
ନାଇଁ ଗୋଟାଏ ଫୁଲ ଡେ ପାଇଗଲେ ଗୁଡାଏ ପ୍ରୋସିଡ୍ କରିଦେଇପାରିବେ।
obviously ସେ ଦିଟା ଲିଷ୍ଟ ହଉଛି, ଗୋଟେ so କଣ କରାଯିବ? ଫାର୍ଷ୍ଟ ଆୱାର ଡିଭିଜନ ବେଞ୍ଚ, ସେକେଣ୍ଡ ଆୱାର ଇଏ ସବୁ ହେଲା।
ସେଇ ଆରେଞ୍ଜମେଣ୍ଟ ଅଫ ବେଞ୍ଚଟା ଆପଣଙ୍କୁ ଡିଫିକଲ୍ଟିରେ
that is otherwise ଇଏ
ନହେଲେ ଯଦି ପୁରା ଦିନ ସିଙ୍ଗଲ ବସନ୍ତେ
that is the main problem.
ସେ ଭଲ ହୁଅନ୍ତା। ମଙ୍ଗଳବାରକୁ ରଖିଲେ
ମଙ୍ଗଳବାର 3ଟା।
5th